Hey, Fran, good morning. This is Paul. Just, you may want to mute your mic. All your shuffling and stuff is coming
Oh,
through.
I'm sorry.
You got a pretty good rhythm, though. You see you're going through every page in 3 or 4 seconds.
Yeah, I am. I'm just getting my documents in front of me. Are we starting with OPC and what witness are we starting with? Coppola?
I believe so. That's the notes that I took from Friday afternoon.
Okay.
So I think it's Coppola, Watkins, Garrett, and then for staff, it's David, Tesfaye, Hauer, and McAuliffe.
Okay, I think everybody said they don't have cross for Watkins.
Maybe for Tesfaye too.
Okay. Okay.
That's true, Fran. We're still waiting to hear whether Her Honor has questions for Glenn, though.
Okay.
Mr. Court Reporter, we can go on the record.
We're on the record, Your Honor. Thank you.
Thank you. Good morning, everyone. Today is Monday, January the 11th, 2021. We're here for day 3 of Maryland Public Service Commission case number 9651, which is in the matter of the application of Washington Gas Light Company for authority to increase existing rates and charges and to revise its terms and conditions for gas service. It looks like we have everyone here this morning. I have a few housekeeping matters before we get started with the first witness. First, has any party not received bench exhibit or bench data request 1 and 2?
Your Honor, if I may, I forwarded to counsel from Montgomery County and GSA bench exhibit 1 only. Let's see if I get that right.
2, bench exhibit 2.
Two only. So, thank you.
As bench exhibit 1 is confidential. Thank you. Okay. Is there any objection to me admitting bench exhibit 1 and 2 on my own admission, 1 confidentially at this time? Ms. Francis, I see you raising your hand.
Yes, we just started to look at it this morning, and I haven't had a chance to talk to Mr. Oliver. I want to review some of the numbers, see if we believe they're accurate. We had asked for that, and while I appreciate your honor getting that in terms of a bench data request, I would like to have a chance to look at it before we move that into the record.
Sure. I'm going to put a place marker in my notes after OPC's witnesses to readdress this. So
Could we address it during the break so I have a chance to have a call to Mr. Oliver, maybe after Mike Ross of Mr. Valencarengi?
Okay.
Thank you.
I received emails from the parties indicating that there is no cross-examination and the parties are willing to stipulate to the testimony of OPC witness Watkins and staff witness Tesfaye. I'm going to go ahead and release those two witnesses at this time. Sorry, I didn't get back on OPC witness Watkins. I reviewed my notes. I think our schedule for this morning is we'll go ahead and admit AOBA's testimony. We'll go ahead and admit GSA's testimony. And then we'll go with OPC's case, which I believe is just witness Coppola at this point, and OPC will admit the testimony of Watkins and witnesses Watkins and Garrett. And then we'll move to staff. And I believe the order that staff gave on Friday is Mr. Valencarengi and then witness Tesfaye, who has been released, and then witness Hauer, and then witness McAuliffe. And then staff should at some time also introduce the testimony of witness Kuykendall. If I'm wrong on any of those points, please speak now or forever hold your peace.
It's correct
Okay.
as the staff, Your Honor.
Okay, thank you. Does anyone else have any preliminary matters before we get to the evidence this morning? Okay, I'll turn it over to Ms. Francis for AOBA. Ms. Francis, you're on mute.
Your Honor, I would like to mark for the record the direct testimony of AOBA witness Timothy B. Oliver, filed on November 20th, 2020 as AOBA Exhibit 1.
AOBA Exhibit 1 is marked, and since the parties have stipulated, it is admitted at this time.
AOBA would also like to mark the direct testimony of AOBA witness Bruce R. Oliver, also filed on November 20th, 2020, which includes an errata, that was filed on January 4th, 2021 as AOBA Exhibit 2.
AOBA Exhibit 2 is marked and admitted at this time by stipulation of the parties.
And AOBA would also like to mark the surrebuttal testimony of AOBA witness Bruce R. Oliver, which was filed on December 21st, 2020 as AOBA Exhibit 3.
AOBA Exhibit 3 is marked and admitted at this time by stipulation of the parties.
Thank you, Your Honor.
Does that conclude your case, Ms. Francis?
Yes, it does, Your Honor. Thank you.
Thank you. We'll move to GSA. Ms. Singleton.
I had to unmute.
Oh, sorry.
GSA would like to the rebuttal testimony of Dr. Dennis Goins as GSA 1, and that's the only testimony.
GSA 1 is marked and admitted into the administrative record at this time by stipulation of the parties.
Thank you.
Montgomery County, you do not have any exhibits to admit, any testimony to admit at this time. Is that correct?
That's correct, Your Honor.
Okay. Okay, Office of People's Counsel. Who's up? Mr. Cleaver.
Yes, thank you, Your Honor. Good morning.
Okay.
Your Honor, as you noted earlier, Mr. Coppola is the only OPC witness who will be appearing. Shall I mark and identify all of the OPC testimony at this time, or shall we go through Mr. Coppola and once the company's finished crossing him and Your Honor asks some questions and he's off the stand, then proceed with the remaining testimonies?
Whichever is your pleasure, Mr.
Okay,
Cleaver.
I think I'd prefer the latter if that's okay with Your Honor. So I would prefer to, for Mr. Coppola's time on the stand to be concluded, and then we'll visit the idea of entering the other two if that's okay.
Yes, sir. Yes, sir.
Thank you.
I
Thank you.
see Mr. Coppola. Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Can you spell your first and last name for the court reporter, please?
Sebastian Coppola, Sebastian
Thank you. Your witness, Mr. Cleaver.
Thank you, Your Honor. Good morning, Mr. Coppola.
Morning, Ms. Cleaver.
You've
Mr.
already
Cleaver, I'm
stated,
sorry. Can you pause just for 1 second while I retrieve
Yes,
your
Your Honor.
document? Thank you. I apologize, Mr. Cleaver. My printer's in another room. You can go ahead.
no problem, Your Honor. I understand. Thank you. Mr. Coppola, would you please state the name of your business and its address and location?
Corporate Analytics, 5928 Southgate Road, Rochester, Michigan, 48306.
Thank you. And would you please state the position that you hold at Corporate Analytics?
I'm president of the company.
Thank you. Mr. Coppola, do you have before you a document entitled Direct Testimony of Sebastian Coppola, public version, which was filed in this case on November 20th, 2020?
Yes.
And does that document include 92 pages of narrative? Sorry, there's an alarm going off in the background. And does that document include 92 pages of narrative testimony? Your
Yes.
curriculum vitae, labeled Appendix A, a series of exhibits beginning with the prefix SC, and a series of data responses by the company to data requests?
Yes, it does.
Your Honor, I would like to have Mr. Coppola's pre-filed direct testimony, public version, marked for identification as OPC Exhibit 1.
OPC Exhibit 1 is marked.
Close the door. I apologize. Yep. I apologize. Mr. Coppola, do you have before you a document entitled Direct Testimony of Sebastian Coppola, confidential version, which was also filed in this case on November 20th, 2020?
Yes, I do.
And does that document also include 92 pages of narrative testimony, your CV labeled Appendix A, exhibits SC1 through SC13, and a series of data responses by the company to data requests?
That is correct.
Your Honor, I would like to have Mr. Coppola's pre-filed direct testimony, confidential version, marked for identification as OPC Exhibit 1C.
OPC Exhibit 1C is marked.
Thank you. Mr. Coppola, do you have before you a document entitled Sir Rebuttal Testimony of Sebastian Coppola, public version, which was filed in this case on December 21st, 2020?
Yes.
And does that document include 81 pages of narrative testimony, exhibits SC-SR 1 through 11, and a series of data responses by the company to data requests?
It does.
Your Honor, I would like to have Mr. Coppola's pre-filed Sir Rebuttal Testimony, public version, marked for identification as OPC Exhibit 2.
OPC Exhibit 2 is marked.
Thank you. And finally, Mr. Coppola, do you have before you a document entitled Sir Rebuttal Testimony of Sebastian Coppola, confidential version, which was filed in this case also on December 21st, 2020?
Yes, I do.
And does that document also include 81 pages of narrative testimony, exhibits SC-SR 1 to 11, and a series of data responses by the company to data requests?
Yes.
Thank you. Your Honor, I would like to have Mr. Coppola's pre-filed Sir Rebuttal Testimony, confidential version, marked for identification as OPC Exhibit 2C.
OPC Exhibit 2C is marked.
Thank you. Mr. Coppola, were these documents before you prepared by you or under your supervision and direction?
Yes.
Do you have any corrections or deletions to make to your testimonies at this time?
Yes. With regard to my rebuttal testimony, I have a couple of changes on page 75. Line 1 on that page should refer to merger commitment number 44 and not number 28. On line 2, the reference to merger commitment 44 should be 28. And on line 4, the reference should be to merger commitment 28 and not 44. There's some transpositions there. Also on page 81, on line 6, makes reference to direct testimony. It should say sewer rebuttal testimony. That is it.
Thank you, Mr. Coppola. If you were asked the same questions today under oath as were posed in your pre-filed testimonies, would your answers be the same?
Yes.
And for these reasons, do you adopt these direct and sewer rebuttal testimonies as your sworn testimony in this matter?
I do.
Thank you, Mr. Coppola. Your Honor, I move that OPC exhibit numbers 1, 1C, 2, and 2C be admitted into evidence.
Is there any objection? Hearing none, OPC exhibits 1, 1C, 2, and 2C are admitted into the administrative record.
Thank you. Your Honor, the witness is now available for cross-examination.
Okay. Washington Gas, do you want to do cross-examination first?
We're happy to do that, Your Honor.
Washington Gas, go ahead.
Thank you. Good morning, Mr. Coppola. I'd like to start by making sure you can hear me okay.
Yes, again, Mr. Dutch. Good
Well,
morning.
it's nice to meet you virtually. We've been on phone calls before, but it's nice to see you.
Likewise.
I'm going to go out on a limb and say that you have the best chair at this virtual hearing. You look like Jean-Luc Picard sitting there.
Yes, yeah. It's got seatbelts on it too, so in case it gets wild, I'm restrained.
Well, I hope it doesn't for both our sakes. Let's dive in, Mr. Coppola. With respect to certain construction-related capital expenditures the company is proposing to move into rate base, is it fair to say you have been critical of the company for not providing sufficient information to justify its proposed rate increase? Is that correct?
Yes, yeah, both in terms of direct and in responses to discovery.
Thank you, sir. This is your first appearance before this commission as a cost of service witness. Is that correct?
That is correct.
I would like to go over with you the materials that Washington Gas filed with the commission to initiate this proceeding and discuss whether you reviewed those materials. Can we agree that on August 28th, 2020, Washington Gas filed a cover letter with the commission asking it to docket this case?
The application, yes. Yeah.
And did you review specifically the cover letter?
The cover letter, yes, sure.
And as you referenced, in addition to the cover letter, the company filed a short narrative application describing its revenue increase requests. Is that correct?
That's correct.
Did you review the application?
Yes.
Accompanying the cover letter and the application were copies of the company's direct testimony exhibits. Is that also correct?
Correct.
Did you review the company's direct testimony and exhibits?
I reviewed the testimony of those witnesses that pertain to my scope of work.
Fair enough. Thank you for that clarification. The company also filed that day what it characterized as compliance materials. Is that correct?
Correct.
Did you review the compliance materials?
Yes.
Also on August 28th, Washington Gas filed a cost allocation manual. Is that correct?
Correct.
Did you review the cost allocation manual?
To the extent that was necessary, yes.
Let's jump back a bit to the company's cover letter, which has been admitted into the record, I believe, as part of WGL Exhibit 3. I provided a separate copy for ease of reference to your counsel. Do you have the cover letter in front of you?
Let me bring it up. Yes, I have it in front of me now.
Thank you. You have just indicated that you reviewed the cover letter prior to preparing your direct testimony, correct?
That is correct.
The first sentence of the cover letter cites to Comar 20.07.04.09. Do you see that?
Yes, I do.
Mr. Coppola, can we agree that Comar refers to the Code of Maryland Regulations?
I believe so, yes.
Thank you. I would now like you to take a look at what has been pre-marked as Washington Gaslight Exhibit CC, which is a copy of Comar 20.07.04.09. Do you have that?
I have a set of exhibits here from the company, starting with AA. Do you know what page of the PDF that is?
I don't. It's probably within the first 10 pages or so.
Okay, let me scroll down.
Take your time. And while he's doing that, Your Honor, I would mark as WGL Exhibit 28 this copy of Comar 20.07.04.09.
WGL Exhibit 28 is marked.
And we would move its admission.
Any objection? WGL Exhibit 28 is admitted.
I have it in front of me now.
Thank you, Mr. Coppola. Let's focus for the moment on subpart C, as in cat, of that rule provision. Let me know when you're about halfway down that page at subsection C.
I think there may be a numbering problem here. At least on my version, exhibit CC follows. What follows that is a letter from Public Service to the Public Service, or from the Public Service Commission. Should it be DD, perhaps?
Well, let's look back at BB, as in boy, boy. I know we had a couple of versions of our exhibit list, and my cross is based on the original one. But again, sir, I'm trying to direct your attention to Comar.
Okay, let me,
So,
BB. Okay, yeah, it is BB.
thank you, and I apologize for the mix-up.
Mr. Dodge, are you able to share the document?
I am not this morning. I don't know if Mr. Buckley or Mr. Kane can do that.
Okay, thank you. It's fine, Mr. Dodge, go ahead.
Thank you. Mr. Coppola, are you able to identify section C as in cat, which is about halfway down the printed page?
Yes, I have it in front of me.
In your review of the company's application package, did you identify, excuse me, there goes my energy efficiency measure. I'll repeat the question. In your review of the company's application package, did you identify any deficiency in information required under subpart C of Comar 20.07.04.09?
I made no reference to any particular rule. I asked the company in a data request where it had explained what the increase in rate base of about $126 million related to specific projects, justification for that increase, any support to that. And, the response was that it was a legal response. The company was not required to do something to that effect. So I did not make any reference to any particular filing requirement.
Thank you. I appreciate your answer, and we're going to cover a lot of the ground implied in your answer in the next few minutes.
Okay.
If you could look at the company's cover letter again, please. And I believe the cover letter now is formally known as WGL3, but you should have that separate courtesy copy.
I have it in front of me. This will be the August 28, 2020 cover letter?
That's correct, sir.
Okay.
And if you could turn to page 2 of that cover letter.
I'm there.
I direct your attention, sir, to the, I believe it's the second full paragraph that has one sentence, and it reads, Washington Gas is filing concurrently herewith the information specified in the letter dated April 18th, 1983, issued by the Commission's Executive Secretary to expedite the processing of rate cases, colon. Do you see that sentence?
I do, yes.
Did you review the April 18th, 1983 letter issued by the Commission's Executive Secretary before preparing your direct testimony?
I have reviewed it. I'm familiar with it. These are minimum filing requirements. Doesn't mean that it should be limited to that, but
We'll get to that too, Mr. Coppola.
Okay.
Let me repeat my question because I'm not sure you answered it directly. Did you review that letter prior to the preparation of your direct testimony?
no, I did not. I didn't see no need to do that.
Your Honor, we would mark as WGL Exhibit 29. Now I'm a little tentative about using our pre-marked designations, but the 1983.
What has been pre-marked as a WGL Exhibit DD, the 1983 Commission Rate Case Guidelines?
Correct.
Yes, it's so marked.
Thank you. Do you have that, Mr. Coppola, the 1983 letter?
I think, let me pull it up. I think it was set as part of that set of documents you sent. I think it's CC in the file that I have here. Yes.
Yeah, I think you referenced that before.
Right. I have it.
If you could scroll down, it may be page 6 of the PDF, but I know it's page 3 of the letter, the 1983 letter, and let me know when you're there, sir.
Page 3 of the letter is the signature page.
No, sir, the numbered page. I apologize. There's an attachment to the letter entitled Information to be filed concurrently with any base rate application. And I believe that is page 4 of the PDF.
My PDF has got different page numbers, but I think I have page 3 in front of me of the attachment, which would be on page 1 of the attachment. It's labeled Information to be filed concurrently with any base rate application. Is that the one?
That's where we should be. Thank you, sir. And if you flip over two more pages to page 3 of the appendix.
Page 3 of that attachment, or is that an
Yes,
appendix to it?
Page 3 of the attachment that you just identified by title.
Okay, I'm there.
And do you see Roman numeral 2, the header Information concerning the applicant's proposed rate base? Do you see that section?
Yes, I do.
I'm hoping we can agree, Mr. Coppola, that on this page, Roman number 2 reflects what rate base information the Commission expects a utility to file in its base rate case application.
I think these are, as I said earlier, minimum filing requirements. And, we can get deeper into parts of it, but again, if the company needs to support certain costs, then it needs to support certain costs. And there's no limitation on adding more information that supports the request.
Oh, I appreciate that answer. I direct you back to section 2. These are the Commission requirements in writing. Is that your understanding?
As of that date, there appear to be, yes.
Do you know of any changes since this was issued in 1983, sir?
I do not know. But the Commission typically, in orders, will issue policy statements and supplement minimum requirements by asking the company to provide additional information to make its case. So again, to just point to something back in 1983, where we're now in 2020, I'm not sure how fruitful this is. Or
in your direct or rebuttal testimony, sir, did you cite to any commission orders directing Washington Gas to provide information beyond the guidance contained in this 1983 letter and package?
I think you're missing the point of my testimony.
Sir,
my request.
I'm not here to debate. I would like you to answer
Your Honor,
the question.
could the
as
witness
asked.
be permitted to answer the question?
I don't believe that the witness was answering the question. Mr. Dodge, will you ask the question again, please?
Mr. Coppola, in your direct or rebuttal testimonies, did you identify any commission orders changing the information noted in the 1983 letter and accompanying attachment?
No, I did not.
Let's go back to your direct testimony, and I'm hoping you have a copy of that handy.
Yes. I have it.
I'd direct your attention to page 12, line 14. Please let me know when you're there.
I'm there.
I'm going to read a passage from that section, and I'd like to make sure I read it accurately. If you could check that after I read this. You state, "It is reasonable to expect that the company would file testimony to identify the key plant categories where capital expenditures were incurred, the major projects, within those plant categories where expenditures occurred, a full explanation of those projects and related costs, the specific work performed, the reasons or drivers for undertaking those projects, explanations and justifications for any cost overruns above estimated amounts, and other evidence that the costs were reasonable and prudently incurred. None of that information is present in the company's filed case." Did I read that accurately?
That is correct.
Mr. Coppola, let's go back to the Commission's 1983 rate case guidance, the same page, section 2. Let me know when you're there, sir.
I'm there.
Mr. Coppola, can you show me in section 2 of the Commission's 1983 rate case guidance the requirement that with respect to its rate-based costs, a utility is required to file, quoting from your direct testimony, a full explanation of those projects and related costs, the specific work performed, the reasons or drivers for undertaking those projects, explanations and justifications for any cost overruns above estimated amounts, and other evidence that the costs were reasonable and prudently incurred?
I'll take you to page 4. And if you go down to paragraph J, it says supporting work papers showing all detailed calculations underlying all pro forma rate-based adjustments. Work papers should also include brief narrative explaining the detailed calculations, if not self-evident.
Does subsection J use any of the language that you use in your direct testimony about cost overruns, full explanation, project drivers, any of that?
Again, these are minimum filing requirements the commission issues. It doesn't prevent the company from justifying its $126 million increase in rate base with basically no explanation.
Your Honor, I would ask that you direct the witness to answer the question as asked.
Your Honor, the witness did
I
answer the
believe that
question.
he answered the question and then added a little something extra. So as long as he's answering the question, I'm fine with it. I understand your need to complete the record on this issue for what it's worth, Mr. Dodge.
Thank you. Again, Mr. Coppola, in your direct testimony, your sir rebuttal testimony in this matter, do you identify any Maryland law, rule, commission decision, or policy that obligates any utility to file this full explanation as you have described it in your direct testimony?
I'm not a lawyer, so I can't quote law.
Well, I'm not asking you to quote law. I'm asking you if you included any reference to any law, rule, commission decision, or policy. I'm not asking for a legal opinion, just whether you included any reference to those items in your direct or sir rebuttal testimony.
I did with regard to certain matters in terms of commission decisions and policies in the past.
Regarding filing requirements, sir?
No, not filing requirements. Your question was broad. You didn't premise it.
Thank you for that correction. In fact, in your sir rebuttal testimony, you referred to Illinois and Michigan filing requirements. Is that correct?
I did not. I gave two examples of what other utilities around the countries are doing that I'm aware of.
I apologize. You may have clipped out. Did you say you did not reference Illinois and Michigan filing requirements in your sir rebuttal testimony?
Did not state any requirements. I said these are examples.
Thank you for that clarification. But you didn't reference anything from this state where you're appearing today.
In terms of what?
Examples of filing requirements beyond what we discussed in context of the 1983 letter.
No, it was not necessary.
If you could turn now to Mr. Coppola, what was preliminarily marked, well, I won't go down that road again, the preliminarily marked. It is the company, excuse me, OPC's response to WGL data request number 3. And this is a package of, I believe, 35 responses. And I believe that was marked for the record as WGL 30.
Yeah, let me pull that up. I think in the initial documents that we got from you, I only had 3 data request responses. Are you limiting it to just that one, or should I pull the whole set we sent to you?
The whole set, please. And I believe we followed up with a corrective email supplying the entire batch.
Yeah, you probably did. I think Mr. Cleaver mentioned that.
You have plenty of time. Take your time.
Sure. Okay, I have him in front of me.
And if you could turn rather to your response to WGL 3-2. I'm so used to quoting from Mr. Cleaver's data request that I got a little mixed up there. But this is WGL 3-2.
I have it in front of me.
Mr. Dodge, it may be useful if, I understand that you can't do it, but if WGL could resend a copy of the document that you're, evidence that document that you're looking at to myself and to all the parties, one of us may be able to share this for you this morning.
That would be great. I believe Ms. Ward is monitoring on the public channel, and I'm going to text her right now to send that to your attention and Mr. Cleaver's attention. Just a moment, Your Honor.
Thank you.
And Your Honor, this is Paul Buckley. I know that it doesn't necessarily help, and most people have little tolerance or patience for technical issues. we believe we actually have identified why Washington Gas employees are having difficulty sharing documents. Our video and sound qualities are just fine. Because we used to use the WebEx software and then transitioned to Teams, for some reason, the laptops that still have WebEx on it run into a problem when we try and share. So, unfortunately, I can't easily help you out. I've gotten a workaround for some of the documents I'll use during cross, but otherwise I'd jump in and help Mr. Dodge, but unfortunately I can't.
I too have run into that problem. I have several different platforms for several different types of meetings, but I can help this morning once I receive the document. But we don't need to wait, Mr. Dodge. You can go ahead and.
Thank you. I've texted Ms. Ward, and I hope she's out there in the ether listening or reading, and we'll follow up very shortly with that request.
And if I receive something, I will share, but you can go ahead with your cross.
Thank you. Thank you for your patience, Mr. Coppola. Are you at the response to 3-2?
Correct. Yes, I'm there.
And following up on my prior questioning, this data request gave you the opportunity to provide references to Maryland law or policy regarding your assertions that the company's case in chief must include the detailed information we've gone over this morning. Is that correct?
That's what the question requests, yes.
And your response says, based on your experience in various jurisdictions, but your response does not cite to Maryland. Is that correct?
Objection, Your Honor. OPC noted a timely objection to this question. And as Your Honor can see here, the objection, OPC objected to this request on the grounds that it seeks a legal opinion and or conclusion. We did provide an answer to the question, as Your Honor can see, which is the preferred practice, of course, for counsel, whether before the commission or courts, to answer the question and then deal with the objection later so that we don't bottleneck discovery. So we objected to the question, but we provided an answer to the company. And OPC stands by its objection that this is an improper question for Mr. Coppola and that it seeks a legal opinion.
Your Honor, if I may be heard?
Yes.
By its express language, the request does not ask for a legal opinion. I asked whether the witness in pre-filed written testimony referenced Maryland law. I didn't ask him to render an opinion under Maryland law, simply whether he referenced law or policy. It's a simple, factual question.
The question asks for references to law that support the opinions. I understood the question to be the opinions contained within the cited portion of the testimony, and then the question is, and provide us with references to law that support what you said in this part of your testimony. That is asking for a legal conclusion.
What we're going to do, folks, is we're going to go ahead and admit this exhibit, and the exhibit will stand for exactly what it is. The answer to the question is within the document itself. And Mr. Dodge, you can move on.
Thank you. You noted earlier in response to my question, Mr. Coppola, this is your first time appearing as a cost of service witness in Maryland. Is that correct?
With regard to filing testimony in the rate case, correct. I did prepare a report for OPC relating to the financial health of Washington Gas Light and Alta Gas in case 9449. That was last year, I believe, or the year before. Now time passes. So I'm familiar with Washington Gas Light and Alta Gas.
In that report that you filed in case number 9449, you proposed 4 rate case conditions. Is that correct?
4 rate case conditions. I'm not sure what you're
Let me read them to you to refresh your recollection. You requested that the commission impose the following conditions on Washington Gas. Number 1, adjust the actual cost of new debt to the cost of debt of an A-rated company. Number 2, quantify other credit costs imposed on Washington Gas's post-merger operations. Number 3, require AltaGas or WGL Holdings to reimburse Washington Gas for increased expenses or interest costs resulting from the merger. And number 4, remove the impact of debt double leverage from its equity ratio. Do those sound familiar to you, sir?
Yes, they do.
The commission rejected those proposed conditions, isn't that correct?
As I understand, the commission decided not to pursue any further review or analysis or other recommendations that OPC council made. I don't think they got specific on those recommendations.
Do you recall that the commission said that the proposed conditions were premature?
I don't remember the exact language, but it could be.
Did you or any other OPC witness raise these conditions for consideration in this case?
I don't believe exactly as I worded them, but some of the issues were raised, particularly with capital structure, and perhaps related issues. I didn't file that testimony, so I can't get into the details.
Thank you. I appreciate your clarification and response. Let's change gears a little bit, Mr. Coppola. I'd like to ask you some questions regarding Washington Gas's pension and OPEB plans. First of all, if you wouldn't mind, for the clarity of the record, sir, can you tell us what OPEB stands for?
Yes, it's other post-employment benefits.
How about other post-employment benefits?
What did I say?
I think you may have deleted the word employment, but that's okay.
Okay.
Can you describe generally what OPEB and OPEB plan might include?
Well, it's a funded plan. Typically, it covers, for the most part, medical expenses pertaining to retirees from a company. The company is obligated through a trust to fund those future obligations that it has, and make sure the money is there when needed.
That's an excellent definition, sir. Thank you. Could you also take a crack at describing a regular pension plan for us?
Yes, the pension plan outlines certain benefits, typically upon retirement, typically related to number of years of service with the company, and it has certain formulas on how payments are calculated. Again, it's a trust deed plan where the company is obligated to fund that plan and make sure that, again, the money is there when pension payments are due.
Thank you, Mr. Coppola. My understanding, sir, is that in your direct testimony, you proposed a cost of service adjustment which reduces pension and OPEB expense. Is that correct?
Correct.
Am I also correct that the basis for your expense reduction is based on your disagreement with the company's expected rate of return on the planned assets invested in various stock and fixed income securities?
Yes.
And you address this disagreement in your direct testimony with respect to OPEB expense at page 67, lines 7 and 9. Is that correct?
Let me double check. Probably correct. You said page 67?
I believe so. 67 of your direct, lines 7 to 9.
Yeah, my testimony on the OPEB and pension expense pro forma adjustment 14 and 15 starts on page 65. Did you have a specific questions on page 67?
Yeah, I just want to clarify the numbers for the record, sir. I understand your direct testimony to state that you used actual 2019 return assumptions of 5.75% for the union portion of the OPEB plan and 3.5% for the non-union portion of the OPEB plan. Is that correct?
I guess help me out here. Where are you looking?
Well, I'm trying to understand from your testimony whether those are the figures you used in your calculations of the cost of the expense reduction?
Your Honor, the witness asked for a citation to the page and line of his testimony that Mr. Dodge is referring to, so he can answer the question. Could that be provided, please?
Mr. Dodge, I heard you the first time you asked the question, what the page and line site was. Can you restate that, please?
I believe it's page 67. I'll scroll down myself. And Mr. Coppola is right. The section or the analysis starts on page 65. But I'm trying to understand from page 67 what actual numbers Mr. Coppola used.
Perhaps I can help you. If you go page 66, line 3, where I begin the discussion, and I say there, for 2020, the company used two expected return rates, a rate of 4.5 for the union part of the plan and a rate of 3.25 for the non-union part of the plan. In the prior year, the company used a higher expected return of 5.75 and 3.75 for each part of the plan, respectively. The 2020 actuarial report lowered the expected return assumption by 75 and 50 basis points, respectively. Later on page 67, where I think you were seeking my response, on line 10, in effect, I say the 2019 expected return assumptions of 575 and 375 are the minimum rates that should have been used to calculate OPEB expense for 2020. So in effect, I'm adopting the 2019 expected return that the company had used for 2020.
So for clarity, you did use the 5.75 and the 3.5% figures.
Yes, those were the 2019 expected return assumptions. I think those are reasonable for 2020. I didn't see a need to change those based on the information that the company provided.
Thank you. I think that clears up it for me, at least. I appreciate your clarification. Now, turning to the pension plan, I believe you discussed this at pages 70 and 71 of your direct testimony. You used a 5.75% expected return. Is that correct? I believe at lines 5 and 6, perhaps you referenced that.
Yes, here again, I looked at what the company was proposing for 2020 or assumed, which is a rate of 5.25. And in the prior year, the company used a higher expected return of 5.75. So I adopted similarly here the 2019 rate for 2020 as a more reasonable rate.
Thank you, Your Honor. Mr. Coppola, as part of your analysis of the OPEB and the pension plan, did you review the assets contained in each plan?
The assets?
Yes, sir.
You're talking about the investment in individual stocks or securities?
That's correct.
That is information that will be monumental to look at. And I did ask the company to provide the returns during the past 10 years in each of the plans, the OPEB and the pension plan. And the company only provided, I believe, seven years, and year to date 2020. That suffice from my standpoint. Reviewing individual stock investments or fixed securities would be of particularly no use.
So the answer is no, you did not review the assets in each plan?
No, I didn't see any purpose to do that. It would be fruitless.
If you could turn back, excuse me, to page 67 of your direct. And I'm going to ask you a series of questions, again, to clarify the record for briefing purposes. You referenced the company's response to OPC data request number 8-15F as in Frank. Is that correct?
Correct.
And here, I believe you're referring to historical returns achieved in the OPEB and pension plans. Is that correct?
Yes.
Am I also correct, sir, that the historical returns were contained in a confidential Willis Towers Watson actuarial valuation report?
I'm not sure exactly which document you're referring to. Perhaps if you can point me to that.
Well, sir, I'm trying to find out from your testimony what you were referring to.
I was referring to data request OPC 815.
And what was provided in response to 815? Well, let me ask it this way. OPC 8-15F was actually a follow-on to OPC DR 5-41B as in boy. Is that correct?
Let me pull it up and check. I don't remember.
And again, I'm not going to cross you on your knowledge of the document. I'm just trying for the record that if folks want to cite to the correct data response, that the WTW report was actually appended to OPC DR 5-41B as in boy.
When you say the actual WTW report, you're talking about the actuarial report?
Correct.
Yeah, I reviewed that. I don't specifically remember them listing individual returns by year. They could have been there. But yeah, I got that information for 7.5 years from the company, as I stated in my direct testimony.
Now, as I stated earlier, Mr. Coppola, that is a confidential report, and I'm not going to delve into any confidential information. But as part of your rate-making analysis for this case, did you review any other public companies' OPEB or pension plans?
I did review certain information that I disclosed in my direct testimony with regard to a number of municipal organizations that was a survey available, and I made reference there in my testimony about what rate of return, expected rate of return they've been using over the past few years.
And did you describe the assets in these other companies' plans in your direct testimony?
Did I explain the assets? You're talking about the mix of assets, such as debt and equity?
That's a good start. Yes.
I didn't get into those specifics. I filed a report as an exhibit, so it's there.
Mr. Coppola, could you describe for us today which of these other companies determined their expected rate of return assumptions in conformance with U.S. GAAP?
I would say, unless you're a private company, and even in those situations, you need to comply to U.S. GAAP.
So your testimony is that all of the companies you examined conform to U.S. GAAP?
U.S. GAAP or the comparable for government agencies.
All right, thank you. Time to turn the page literally again. I think it's fair to say, Mr. Coppola, that you have been very critical of the company's design processes with respect to construction projects. Is that correct?
I wouldn't characterize as very critical. I just outlined where I saw deficiencies and where I saw areas that showed either poor management or incomplete disclosures or other problems that reached the point of being imprudent.
Have you also been critical of the company's estimated costs associated with the three types of projects that you've examined in your testimony? And by that, I mean regular construction projects for distribution plant, stride projects, which pertain to accelerated replacements, and regular transmission projects?
I missed the first part of your question. Could you try again?
Sure. I'd just like to know if you've also been critical of the company's estimated costs.
Yes, I think that's not just my opinion. but the opinion of others. I think this has been an ongoing problem for the company, which I think you have admitted.
I'd like to have a little different kind of discussion with you about this topic, Mr. Coppola, about the philosophy, if you will, of examining estimated costs and actual costs. And I know it's tempting to argue about whether the company could have foreseen a tree falling in a trench or a monsoon or something like that, but I'm going for a higher level discussion here today. Let's start with some basics. Mr. Coppola, how do you define estimated costs?
Well, estimated cost in the generic sense or in the sense of a construction project like the ones that we've been discussing?
Let's focus on the latter, please.
Well, an estimate is an estimate. It's just, you use whatever information is available to you at that point in time that you prepare an estimate, and you assign a cost to whatever components of that project or analysis you're doing, and you do the best you can at that point based on the information you have, taking in consideration, what the entire project entails or may entail down the road.
Very good. How do you define actual costs?
Actual costs are, costs that have been actually incurred and you pay for.
Based on your definitions, can we agree that estimated costs and actual costs are two different things?
Sure.
One of the bases for your criticisms in this case is that the variance between the company's estimated costs and its actual costs. Isn't that correct? That there is a variance?
Well, there are different ways to estimate, and you can just take a simple average like the company does and apply that, or you can do a little more in-depth analysis and come up with better estimates. So there's a range there. I'm not sure if that answers your question, but that's my view.
That's fine. Thank you. I understand that you looked at the company's activities, particularly in the design phase, to understand and perhaps explain the variances, which result in what you call cost overruns. Is that a fair summary of your analysis?
Well, yes. Based on the information the company provided, they had an estimate for each of the projects, and then there were actual costs. And often those overruns or variances, whatever you want to call them, exceeded 100%, 200%, and certainly over 20% of the project cost.
Mr. Coppola, can we agree there are other methods or benchmarks against which either the company's estimated or actual construction costs can be compared to see if they are reasonable from a rate-making perspective?
I'm not sure what you're thinking about. Maybe give me some examples.
Sure. How about comparing a company's estimated or actual costs against other gas utilities conducting similar projects?
That probably will not be too pertinent because each project is specific to a particular area, certain requirements that you have in that particular area. And that's been the basic problem with the company, is that they don't take in consideration, the specific circumstances of that project. They just apply average, territory-wide averages, and that, is a problem. So, to go further than that and then compare to another utility in another state or in a different territory, totally unrelated to the company, I'm not sure of what use that is, other than, if you're doing some high level, perhaps analysis, but that's not what we're doing here.
I'm going to guess I know the answer to my next question, but I'm going to ask it anyway. Would you be comfortable in considering regional or national averages to compare estimated and actual costs?
No, those would not be pertinent to what we're doing here.
How about tools like econometrics or other mathematical models? Would you be comfortable in using those?
I guess I'm not sure what you're thinking there in terms of the econometric models. Again, the further away you get from the specific project circumstances and cost and requirements, you're bound to have things that don't relate and don't matter, and for the purpose of determining prudency, it would not be useful.
So to summarize, your preference, strong preference, it sounds like, would be to look at the facts of a given case within the context of the projects being examined.
I think that's the best way to determine what the project cost will entail, and preparing an estimate, taking all the information that you can get, and come up with an estimate that will give you then information on which you can then manage the project as actual costs come in, and determine how far off you are, or if you're on target, and then manage the project. Right now, that doesn't seem to exist.
Another basic question for you, Mr. Coppola, and I apologize for jumping around a little bit. Is Washington Gas proposing to move its estimated construction costs into base rates, or its actual costs?
Actual costs.
Thank you. If you could bring up WGL Exhibit 29, the 1983 rate case guidelines.
These are the same guidelines we were talking about earlier?
That's correct. In particular, Section 2, concerning an applicant's proposed rate base. Your Honor, I think, there you go. And as you said, Mr. Coppola, we looked at this Section 2 previously, correct?
Yeah, this would be on page 3 of the attachment.
That's correct, sir.
Section 2, I have it in front of me.
Thank you. There is no reference in Section 2 that the company must provide its estimated costs as part of the information concerning its rate base. Is that correct?
No, there is no requirement.
Thank you. Now, if we could turn to what has been marked and admitted as WGL Exhibit 30, that's the batch of our response, OPC's responses to WGL data request number 3.
Which particular number?
Let's start with your response to 3-3, please.
I'm there.
Your Honor, may I seek clarification on a matter related to this? I understand we had a dialogue previously about one of the responses that Mr. Dodge had referred Mr. Coppola to in this packet of data responses, specifically 3.2. OPC, I raised an objection to that request based on the objection that we had timely served. Your Honor overruled that objection and admitted the response. Mr. Dodge's previous question that he just had posed to the witness pre-assumed that the entire packet had been admitted. This is 35 questions. There's objections to many of them. In OPC's view, many of them are inappropriate. And I didn't understand, Your Honor, to be admitting the entire packet. OPC does have objections to a number of these, and beyond that, Your Honor, I would just, in recognizing that, of course, this is Your Honor's decision, but I do know there's been recent direction from the Commission about not admitting exhibits unless there's been cross on them. So I'm not sure how that would play into this as well. But I would just simply note again, and respecting Your Honor's ruling on 3.2, which I thought was limited to 3.2, OPC does object to a number of these coming in, and beyond that, there hasn't really been any questioning on anything other than one of them thus far.
Your Honor, if I may,
Sure.
I intend to walk through several of the responses to elicit factual information. Some of the questions that I ask will be about responses which were objected to, but I don't think that prevents me from questioning the witness to elicit factual information. We recall a discussion from earlier in the hearings where if one admits a package of information, one can only cite to on brief the particular passages that were crossed on. And that would be my intent here. If I don't ask about 3-1, for example, I'm not going to cite that in our brief.
I'm going to earmark the objection and we'll take it up at the end of Mr. Dodge's cross-examination. But go ahead and continue your cross-examination, Mr. Dodge.
Thank you.
Thank you, Your Honor. Are you at 3-3, Mr. Coppola?
Yes, I am.
This question asks for you to provide examples of each construction project you designed in sum. Is that correct?
That's what the question is, yes.
Now, the objection, the third sentence down, refers to construction projects you have overseen. And just for clarity's sake, I'd like to give you the opportunity to answer the original question in yes or no format. Have you ever designed a gas utility construction project?
No, I've not designed projects. I have reviewed designs, but you know, I'm not a project designer.
Thank you. Now, if you could turn to the response to 3-4 and 3-5. Three dash 4 asks about educational background in engineering, and 5 asks for any certifications. Is that correct?
Yes.
And you confirm that you are not trained as an engineer and you don't hold any engineering certifications. Is that correct? Correct.
Yep. I mean, I'm not proposing here changes to technical designs. It's the whole process that I've questioned in my testimony.
A separate question, do you have any certifications as a project management professional?
Project management professional, no, I have experience in it, but no certification.
Mr. Coppola, do you know if you qualify to apply to take either a professional engineering exam or a project management professional certification exam?
I never pursued that.
So you don't know?
No, I've never pursued it.
Let's move ahead to 3-7.
I'm there.
Let me know when you're there.
Mr. Dodge, the document that I just received doesn't have 3-7 under the same. It only has 3-1 through 3-5 as pre-marked as on the exhibit list EE, and this is DD.
Yeah, Your Honor, we circulated the entire package after one of the parties had noted that our original package only had a handful of the responses. And I believe Mr. Buckley, who's on the line, may be able to recirculate that entire package.
Okay, thank you. I'll just stop sharing at this time. Go ahead.
Thank you, Your Honor. And again, apologies for the mix-up. I think you noted that during the hearings, we're doing okay. The document exchange is a little tougher virtually.
Yes, sir.
Mr. Coppola, please let me know when you have 3-7 in front of you.
I have it, Mr. Dodge.
Thank you, sir. I direct your attention to the next to the last sentence in your response. The import I drew from that sentence is that insufficient project planning and scoping can lead to extra costs as contractors try to sort out how to best resolve issues. Did I capture your sentiment accurately?
Correct.
Have you provided any estimate of the level of these purported extra costs in your direct rebuttal testimonies or any discovery response?
No, I did not. The company didn't provide enough detail to be able to sort through all of that. I don't have access to that information unless you disclose it.
OPC served considerable discovery in this case on the company. Is that correct?
Yeah, we had a number of discoveries, but it's not the request; it's the answer that matters.
Did OPC move to compel at any time during the course of this case, to the best of your knowledge?
Objection. The relevance.
It's a factual question. He just said that he didn't have sufficient information. The discovery process is available to OPC. They didn't move to compel anything. The inference is obvious.
Your Honor, what?
Shall I repeat the question, Mr. Coppola?
I'm not sure. Was the objection overruled or?
Overruled.
We did, a number of discovery requests, as staff did as well. I used some of that information. Time just doesn't permit to continually go after and trying to ferret out minute details. It goes to my initial point. If the company had disclosed up front in this direct filed case more information on the projects, then we can, have more time to get into further details. But we had what we had as of the point in time we needed to file testimony.
Mr. Coppola, I'm going to ask you the question one more time with the judges okay. To the best of your knowledge, did OPC file any motion to compel against Washington Gas in this case?
I'm not aware of any.
Thank you, sir. Let's move ahead to your responses to 3-8 and 3-9.
Your Honor, may I just, one more matter related to this and the objections that Your Honor has earmarked. May I have a continuing objection to these questions to the extent that there's an objection noted in the data response? So I don't keep, every time Mr. Dodge says, look at 3-8, you said this, and then we'll, as Your Honor's instructed, deal with it later, so I don't continue to interrupt. Is that acceptable?
Absolutely. Your previous objection as to the earlier 3- questions is continuing, and we'll address it at a later time. And
thank you.
I'm still hoping that Mr. Dodge's helper elves can send a full copy of Exhibit 30. Thank you.
We're hunting for it, Your Honor.
Thank you.
In the blizzard of emails, we're trying to hunt it down.
Thank you.
Your Honor, you may have received something from Tina Ward at Washington Gas, and hoping that her most recent email or a recent email to you includes the entire packet.
Thank you.
And knowing Ms. Ward as I do, she would take as a compliment the characterization that she is a helper elf.
You can proceed. Yeah, you can proceed while I'm. You'll know I found it when I've shared it. Thank you.
Thank you, Mr. Coppola. 3-8 and 3-9. I'd like to summarize to move this along. It seems to be your responses confirm that you did not prepare site-specific cost estimates for the projects you challenge in this matter, and you did not calculate the cost of preparing site-specific cost estimates for the projects you challenge in this matter. Is that correct?
Well, let's take one at a time. With regard to 3A, the question is, did the witness create site-specific cost estimates for each construction project? It's not my job. It's the company's to do that. It's my job to review it and determine whether or not it's reasonable and prudent. With regard to 3-9, your question there is, did the witness calculate the cost of preparing site-specific cost estimates for each construction project identified in his direct and rebuttal testimony? Same answer.
Thank you. If we could page forward to 3-12, please.
I'm there.
The basis for the objection in this response is that the data request calls for speculation. Is that correct?
That's where it says yes.
And just for reference, for record reference, the data request had asked if Washington Gas spent additional resources on a site-specific estimate, the company would have still encountered limited working hours and storage costs. Did I paraphrase that correctly?
I think that's what the question says, yes.
Thank you. And again, the objection is that the data request calls for speculation. Now, I'm not asking you if you agree with the objection. I'm not asking for a legal opinion. Mr. Coppola, I just like to know, in your experience as a rate-making witness, what does speculation mean to you?
Objection, Your Honor. I know I have a continuing objection, but this is a separate point.
Your objection is sustained.
Thank you.
Thank you, Your Honor. Mr. Coppola, by my count, OPC objected to 6 different data requests in this set on the basis of speculation. Will you agree with that number, subject to check?
Subject to check, yes.
All of those data requests, and this is my characterization, that I just listed or referenced, asked in essence whether Washington Gas could have avoided costs at construction sites if the company had performed more work during the design phase. Can we agree on that?
Well, we did answer some of that after the objection, and the point of those answers is that the basic problem is that if you don't have a tool to manage a project with an accurate cost estimate, then you don't know where you are, as I said before, when actual costs come in. So you can't really manage the project to know that you are on target and what you're getting billed is correct. As I said earlier in some of the responses, you get in a situation where the contractor wants to get reimbursed for the extra cost that was not anticipated in the initial bid, and it becomes basically a cost pass-through. So you lack the management tools, and therefore actual cost can be in excess of what they could have been if there was a better cost management process in place.
Well, I appreciate that answer, and I'm glad the path that you took with that answer. But I'm having a very difficult time, Mr. Coppola, reconciling the basis for OPC's objections with your testimony and your proposed disallowances. And perhaps you can help alleviate my confusion. OPC's position, as I understand it, is that 6 data requests that ask whether the company could have avoided costs by doing more during the design phase are objectionable because they call for speculation. Your direct testimony calls for disallowances of certain costs for the projects associated with those 6 data requests. Can we agree on that?
No objection to that particular question as phrased, Your Honor.
I guess pose that one more time, trying to make sure I'm answering the correct question you're asking.
Sure. The OPC's position seems to be that the company could have avoided, your position, sir, seems to be that the company could have avoided costs by doing more during the design phase, and that the data requests themselves are objectionable because they call for speculation. Let's stop there. Can you agree with that summation?
That question, as it was asked, I will object to that, Your Honor. The last one was close, but I think this one is objectionable. Your Honor, I will freely admit, I wrote the objections. I'm a lawyer. I work for OPC. I determine whether or not to object to a question. Mr. Coppola writes the testimony and the answers to the questions. Asking him to try to speculate, no pun intended, on what rationale I may have had to note the objections and to explain how my thinking is consistent with his testimony is irrelevant, and it's highly inappropriate.
I disagree. it seems to me that OPC has put up an objection shield so that the company can't establish that Mr. Coppola engaged in the exact same speculation that OPC objects to in these questions. He engaged in speculation by saying, had we had a better design management process, we could have avoided certain costs. Now, in the objections and the responses, they're refusing to say whether there could have been avoided costs. That's the whole point of this line, Your Honor.
Your Honor, if Mr. Dodge wants to raise that argument in his brief to the extent that these questions and their associated objections are admitted into the record, that's fair game for his brief. But it's beyond the scope of Mr. Coppola's testimony. It veers into inappropriate attorney and expert witness communications, which are immune from discovery under Federal Rule of Civil Procedure 26. And OPC objects to that as a question posed to Mr. Coppola. It sounds like an argument that the company wants to make on its brief.
We will make the argument, Your Honor. I'm simply trying to elicit the witness's position on these data requests.
I'm going to sustain the objection to the question. I believe you've made your point, Mr. Dodge.
Thank you. Let's turn to your Sir rebuttal testimony, sir, page 52, lines 8 to 10. And please let me know when you're there.
Excuse me. Page 8 of my Sir rebuttal on there.
Page 52, sir.
Oh, I'm sorry, 52. I'm there.
Again, my summary, feel free to correct me if I'm wrong. The basis for your disallowance discussed on that page of your Sir rebuttal, at least in part, is that if the company had exercised prudent management during the design phase, it would have avoided additional costs. Is that correct?
Is there page 52 of my Sir rebuttal addresses Mr. Klessen's asset refresh. Is that what you mean? Is there a particular line there you're referring to, or are we off a page here?
Give me a moment. I may have given you the wrong page number. I've been known to do that before.
Yeah.
My apologies. It's page 54, 54, lines 8 and 9.
I'm there on page 54. Which lines did you say?
Overall, it's lines 8 through 10.
Okay.
And I'll read to you from your testimony, sir. You say, with better project planning and coordination with Williams and more effective on-site construction management, several of the additional costs incurred for this project could have been avoided. Did I read your testimony correctly?
Correct, yes.
Well, here's my confusion, Mr. Coppola. Your direct and Sir rebuttal testimonies are very definite that the commission should disallow construction-related actual costs incurred by the company if they exceed 20% of the company's estimated costs for those projects. Is that correct?
I made certain recommendations. You know, the 20% is the beginning threshold, and then most of these projects exceed that 20% by quite a long shot, up to 100, 200%. I guess, what was your question? I'm trying to answer.
I'm trying to ask you if I was accurate in summarizing your position.
Well, the testimony, are you trying to somewhere paraphrase my testimony, or what were you doing?
All I'm trying to establish is that you are certain that the commission should disallow construction-related actual costs incurred by the company if they exceed 20% of the estimated costs. Is that correct?
Not in all cases, as I was saying. I used the 20% as the initial screen, and then I focused on individual projects that, as I said, in most cases exceeded that 20% by quite a bit, up to 200% of the project cost. And then I reviewed what the company's explanation and information provided was in response to a data request, and then reached a conclusion where I thought it was inappropriate to include those actual costs in the rate base.
Thank you. Again, you state in plain language that had Washington Gas had better project planning, additional costs could have been avoided. Is that correct?
Yes.
Sir, you were asked 6 times in discovery whether the company could have avoided some portion of actual costs incurred if the company had done more work during the design phase, including a site-specific inspection for 5 of the 6 projects you've challenged, or by letting a site-specific bid for 1 project. And you wouldn't answer because you felt it required speculation. Is that correct?
Objection, Your Honor. Mr. Dodge is trying to backdoor what Your Honor has already sustained as inadmissible.
Sustained.
Let's move ahead to 3-19, 3-19.
I'm getting there.
We're in the home stretch.
I'm there.
Now, this data request asks for your basis to claim that the company can easily find out what the requirements of the SHA are. Is that correct?
Yes.
Were you monitoring the hearing when Mr. Morrow, company witness Morrow, delivered his live rejoinder testimony?
Most of it, yes. I'm not sure I was there for all of it, but most of it.
After having listened to, we hope, all of Mr. Morrow's, or at least a part of it, do you understand now, sir, that the SHA requirements as used by Washington Gas refer to, at least in part, the on-site authority of SHA inspectors, and that such authority is not written down anywhere or available during the design phase?
I heard that, but I don't agree with it.
So you think that the on-site latitude accorded to SHA inspectors is recorded in writing somewhere?
The inspector will have a certain amount of discretion, but not entire discretion to redo a whole project. He usually looks at what the permit requirements are for the specific projects that SHA issued, and then reviews the construction work completed and matches to those requirements. And if he sees any shortfalls, then he'll point those out to be corrected. I know of no cases that the inspector has full authority to ask the company to redo something if it met the requirements of the permit.
How many SHA related projects have you reviewed outside the bounds of this case?
I reviewed a number of projects in different states, and they pretty much all operate the same way. There is a process where the company requests a permit to do work in the public right-of-way that's under the jurisdiction of the local agency, whether it's SHA or a municipality. And that permit spells out, the company files its plans It describes what we'll do, how it will comply with the published and required requirements for restoration, location, and all of that. And then a permit is issued with specific requirements that the public utility installing a pipeline and doing restoration in a public area needs to comply to. And then the inspector goes, not in all cases, but in many cases, to make sure that the work was done according to the requirements.
I was inarticulate in my question, as so often happens, Mr. Coppola. How many Maryland SHA projects have you reviewed outside the bounds of this case?
I've not reviewed any specific Maryland projects. I'm just describing the process in response to Mr. Moore's point.
Are you confident that you have described the Maryland specific process if you have not reviewed any Maryland projects?
I mean, I haven't seen any specific testimony on the part of the company specific in terms of what the inspector said and how the inspector may have changed something that was not in the permit requirements. So it's hard for me to answer a question hypothetically when I don't have any data on what the company point is with regard to what the inspector may or may have not changed.
Did you hear Mr. Morrow testify that the inspectors, Maryland SHA inspectors meet with Washington Gas after the construction phase of a project is complete?
I'm sorry, ask for that one more time.
Surely. Did you hear Mr. Morrow's live rejoinder testimony that the inspectors meet with Washington Gas after the construction phase of a project is complete?
Well, yeah, that's normally what happens is after the project is completed, supposedly based on the requirements in the permit that was issued by SHA, the inspector wants to make sure it was done according to the requirements that are defined in the permit issued. If it's not done because the company didn't comply with the requirements, that the inspector has every right to say, do it right.
In how many of the projects, Maryland SHA projects that you reviewed in this case, did you see evidence that the SHA inspector determined that Washington Gas did not, to use your phrase, do something right?
Well, apparently, if the responses to the questions asking for explanation that why the cost overrun had incurred, they explained that SHA had required certain requirements in doing certain things. The answer was normally, well, we didn't consider that because we use a kind of generic approach here using averages, and it doesn't consider the specific requirements that the SHA or other municipalities may have. So we have this disconnect that the project estimate doesn't consider this specific requirements, and that is the basic problem. I didn't see anything in the explanations provided by the company to the variances that I analyzed where the inspector all of a sudden came up with new requirements that were not in the permit. That was never disclosed. And I think to some degree, Mr. Moreau was perhaps embellishing the answer.
I beg your pardon, sir? I've never had a witness accuse another witness of embellishing his answer. Can you point me to the specific words that you're referring to, sir?
That the inspector would change the requirements on site.
Were you listening to Mr. Ackes's live rejoinder testimony, Mr. Coppola?
Yes, it's Mr. Atkins. I'm sorry. That's the witness I was referring to. And
do you recall my question to him whether state and local authorities often use the company's construction projects as a lever to pave larger sections of roads that those authorities don't want to pave themselves?
They asked the company to do what?
Let's break it down again. Did you hear Mr. Ackes's live rejoinder testimony?
I heard most of it, but not all of it necessarily. So
Can
what
you define
particular
most
part?
of it? That's the second time, sir, you've used most of it. What do you mean most of it?
I wasn't, tied into all of it. That I was excusing myself from time to time.
So you didn't hear all of Mr. Morrow or Mr. Ackes's live rejoinder testimony?
Not every word of it, no. But if you have anything specific, I can answer it.
Well, I'm trying to do that. I just want to establish your knowledge base so I can formulate the question. Did you hear my question to Mr. Ackes about instances in which state and local authorities require the company to pave an entire stretch of road, not just the immediate area around the construction project? Did you hear my question regarding that?
I did not hear that particular question, but that would be unusual, based on my knowledge, that SHA or other government agency would require work to be done unless it was part of the initial permit requirements.
Well, there's the rub. Do you recall Mr. Ackes's response to my question, Mr. Coppola?
Which was what?
Will you accept, subject to check, that Mr. Ackes responded, "Oh yes, that happens frequently"?
I disagree with that.
Now, I'm not asking whether you would disagree or agree, sir. I'm asking whether you heard Mr. Ackes's testimony.
Yes, I heard something along those lines, yes.
So you hadn't excused yourself from the hearing. You now do remember that Mr. Ackes gave me that answer.
Yes, the context, the way I heard it was that the inspector supposedly was changing or imposing new requirements that were not previously part of the permit requirements that the company received.
What personal knowledge do you have that Mr. Ackes's response was inaccurate or incomplete?
It just goes against everything I know about the way permits work.
Let me rephrase the question. What personal knowledge do you have of Maryland SHA or Maryland counties or Maryland localities that suggest to you that Mr. Ackes's response was incorrect or incomplete?
I have no direct knowledge.
Thank you,
Just
sir.
giving you my view.
I think that's the point of my question, Mr. Coppola.
Thank you.
Just a moment, Your Honor. Mr. Coppola, if you could turn to your Sir rebuttal testimony, page 47, please.
On there?
At the top of that page 47, you discuss BCA or Business Case Authorization 0285166. Is that correct?
Yes.
That is or was a STRIDE project. Am I correct?
Correct.
One reason for affirming your recommendation that the Commission disallow certain costs associated with this STRIDE project is that company witness Ackes did not provide any more details on the incremental costs. Is that correct?
Yes.
I hate to do this to Your Honor, but do you, Mr. Coppola, have ready access to Mr. Ackes's rebuttal testimony? It has been marked and admitted as WGL Exhibit 20, I believe.
I can get to it.
Thank you.
I have it in the particular page you want to go to.
Page 16, please.
On there?
And if you could direct your attention to line 22 on page 16.
Line 22 on there.
I'm going to read two sentences starting on line 22. I'd like to make sure I read them accurately. The two sentences read as follows. The original project design involved direct burying the main behind the curb, anticipating less traffic control and restoration requirements. Due to the presence of
I'm
existing
sorry.
light poles.
Yeah, let me stop you. You said page 16 on Mr. Akas?
Yes, sir. And it's up on the screen if you'd care to look on the screen.
Because, page 16 of the version I have on line 22 says something. Oh, I'm sorry. Yeah, go ahead. Yeah. Starts at the end of that line on page 22.
That's correct. Let me read it again. The original project design involved direct burying the main behind the curb, anticipating less traffic control and restoration requirements. Due to the presence of existing light poles and multiple trees in the green space right of way, the company was required to move its main installation into the roadway. Did I read those two sentences accurately, sir?
Yes.
Mr. Coppola, after reviewing the company's direct case and discovery responses, were you aware of the presence of a green space right-of-way on site at BCA 0285166?
Was I aware?
Yes, sir. Were you aware of the existence of a green space right-of-way?
No, the point is that the company should have been aware.
Could you define a green space right-of-way for me, sir?
Is your question whether or not I was aware of what?
No, my question this time is if you could define the phrase green space right-of-way. Do you know what that means?
I have a general idea what that is.
Go ahead.
Green space would be an area that has got grass or trees normally and not paved.
Do you know if green space rights-of-way are common at the company's project locations?
Maybe, maybe not. I just don't know. It depends on where the project is.
Do you know if green space rights-of-way in Maryland are recorded in a publicly available location?
Never checked that.
Thank you. That's all I have, Your Honor. We would move the admission, or I guess we don't have to move the admission of WGL 30 is in the record. I realize Mr. Cleaver may want to engage in argument on that, but we do think it deserves to remain in the record.
Mr. Dodge, how many data responses are in your version of WGL 30?
35 total, 1 through and including 35.
Okay, and I understand that you have referred to in your case numbers 3.1 through 3.5, 3.7, 3.19. Which ones am I missing?
I think that may be it, Your Honor. Subject to, I can go on the break, I can go back to confirm, but I think you've identified them correctly.
Mr. Cleaver, do you have any objections to those data requests and responses?
So the first sequence of numbers that Your Honor just said was 3.1 to 3.5. Is that correct?
Yes. Also 3.7 and 3.19. I believe I may be missing one, but do you have any objection to the specific?
I think 3.8 and 3.9 were also included in my questioning.
Do you have any? My question, I guess, Mr. Cleaver, is do you have any objection to the specific request referenced by Mr. Dodge in his questioning?
Well, let me walk, if I could, Your Honor, I could walk through these. One, no objection. We didn't note an objection here. Two, Your Honor has ruled on that those objections and overruled the objection. 3 is only an objection. There was no answer provided. So that one, of course, is fine. With as far as OPC is concerned, no objection to that objection coming into the record. I mean, number 4, the OPC position as stated here in the objection is that engineering degree is irrelevant to providing the kind of analysis Mr. Coppola provided. That's why we noted this objection. I note that Mr. Morrow from the company is not an engineer, but for purposes of the questions that were asked about this for number 4, I will withdraw the objection as noted in the response. And I would just say the same thing about number 5. Number 7, let's see. Number 7, I will withdraw the objection noted here based on the questions that were asked and the testimony. What is the next? Is the next one 8, Your Honor?
8, 9.
OPC maintains its objections to 8 and 9, Your Honor. 8 asks about, did you prepare estimates for all the projects you talked about? As the objection states, this represents a burden shift, and same with 9. Did you calculate how much it would cost to prepare estimates for the project you talked about? Same thing. So OPC would maintain its objections to 8 and 9, and then 17.
It's 19.
19. Sorry, Your Honor. Thank you. 19. There was no objection noted to that, so no objections to that, Your Honor. So only 8 and 9, OPC would maintain its objection for the reasons stated in the written objection.
Okay,
Have you heard on 8 and 9?
I'm noting OPC's objection to 8 and 9. I'm admitting WGL Exhibit 30 to include numbers 3.1 through 3.5, 3.7, 3.8, 3.9, and 3.19. I'm directing WGL. Unfortunately, I don't have live notes, so I'm directing WGL to review its questions on cross-examination to see if I've missed any in that number. And I'm directing WGL to send to me and to all of the parties a clean copy of WGL Exhibit 30 containing only those exhibits that were addressed on cross-examination.
We will do so. Thank you, Your Honor.
Thank you, Your Honor. Appreciate that. Thank you.
Again, that's all I have. Thank you again, Mr. Coppola, and I hope that we can meet together in person soon.
Well, thank you, Mr. Dodge. I appreciate that.
Thank you, Mr. Dodge. Ms. Francis,
No
would you like to proceed with your, no questions?
No
Okay,
questions.
GSA.
No questions. And I apologize, Your Honor, for not having video. I'm having some connectivity issues. So when we have a break, I'll restart my computer and see if that helps things. But I keep getting kicked off the video.
No worries. I did note that there's a little yellow button up that says that you're having connectivity issues. And it says bandwidth. Montgomery County.
No cross.
Staff.
Staff has no questions, Your Honor.
Okay. Mr. Cleaver, would you like to do your redirect now, or would you like 5 minutes?
5 minutes would be good for a break, Your Honor.
Okay, now is a good time for a 5-minute break. We will go off the record and we'll come back on at it's 11:53. We'll come back on at noon. Thank you.
Thank you.
We're off the record, Your Honor. Thank you.
We're waiting for counsel for a couple of parties. No problem. Just hang on a second. I'm just waiting on Mr. Dodge to let us know that he's here, and then we'll start.
My apologies, Your Honor. I was actually just sending an email to you and the parties.
No problem. Mr. Cleaver, go ahead.
We're on the record, Your Honor.
Thank you, Mr. Court Reporter.
Thank you, Your Honor. Good afternoon now, Mr. Coppola.
Good afternoon, Mr. Cleaver.
Just have a couple of questions for you. In his cross-examination of you, Mr. Dodge, counsel for the company, asked you a number of questions about Maryland laws or commission policies or commission rules upon which you relied for your testimony that you provided on the company's failure to support certain expenditures being moved into rate base. Do you recall those questions?
Yes.
Okay. Mr. Coppola, could I refer you to your direct testimony at page 13? And line 9. Tell me when you're there. Direct page 13, line 9.
I'm there.
Okay, and here you're discussing your views on the company's the information that the company didn't present in the case that you believe should have been presented. And you stay here at 9 lines. Such a position is fundamentally at odds with the basic precepts of utility regulation for a monopoly business, for which rates are set based on a clear showing of reasonable and prudently incurred costs. Did I read that correctly?
That's correct.
Mr. Coppola, was the prudency standard a policy of this commission that you relied upon in making your points and testimony on that issue?
Yes, this commission, as well as other commissions, have prudency standards and prudency reviews. In order to make that assessment, you need to have basic information on what is being requested and justification for that request.
Thank you, Mr. Coppola. Mr. Coppola, Mr. Dodge also asked you some questions about your testimony on the company's pension plan. Do you recall those questions?
Yes.
And specifically, do you recall the question where Mr. Dodge asked you whether you reviewed individual stocks or securities contained within the pension plan's assets? Do you recall that?
Yes.
And you answered that you did not review individual stocks and securities. Do you recall that?
Correct.
Mr. Coppola, for the record, did you review the average returns for the plans that comprise the same assets that are presently comprised in the plan?
Yes, as I stated in my testimony, I asked the company to provide returns for each of the plans, the OPEB plan and the pension plan, spanning from 2010 to 2019, the actual returns on the investments contained in those plans, which would be an average of the stocks and debt securities that the company has invested in. That bottom line return is what matters. What each individual stock may have done is of no consequence. It's the overall that matters.
Thank you, Mr. Coppola. Mr. Coppola, finally, on the discussion that you had with Mr. Dodge about the statement from Mr. Ackas regarding government agencies or municipalities requiring the company to do more paving than what is actually connected to the gas distribution work, so that the agency or municipality can get some additional needed paving out of the deal. Do you recall those questions and answers with Mr. Dodge?
Yes.
If a state agency or a municipality were to require a regulated utility to make paving repairs that went beyond what was necessary in order for the utility to do the work, so that the municipality could obtain essentially free paving upgrades, would you expect that to be something that the commission would want to look at before determining that ratepayers should be charged with those costs?
Absolutely. It makes no sense for ratepayers to pay for additional costs that the general public should pay through taxes and other funding mechanisms. So that should have been clearly disclosed, and I'm assuming challenged by the company before paying those costs. But again, there's no evidence in the record other than the testimony of Mr. Ackas about that. I didn't see in any of the projects that are reviewed any specific reference to that. If there had been, we probably would have done some additional discovery and follow-up to determine what that cost was, why it was required, and why was it reasonable for the utility to pay for it. So that's very unusual.
Thank you, Mr. Coppola. Your Honor, I have no further questions on redirect. Thank you.
Mr. Coppola, thank you for your appearance this morning. I don't have any questions for you, so you're released at this time.
Thank you, Your Honor. Thank you, everyone.
Mr. Kleber, do you have some other exhibits to introduce at this time?
Yes, Your Honor. I would like to proceed at this time with the OPC testimonies that have been stipulated into the record. I'll begin, bear with me a second, Your Honor, with the testimonies for OPC witness Glenn Watkins. I would ask, Your Honor, that the direct testimony of OPC witness Glenn Watkins be marked as OPC Exhibit 3, and Your Honor, that testimony consists of 28 pages, as well as 2 attachments labeled GAW1 and GAW2.
OPC Exhibit 3 is marked.
And Your Honor, I would ask that OPC witness Glenn Watkins' rebuttal testimony be marked as OPC Exhibit 4. And Your Honor, that, for the record, that testimony was filed on I believe it was December 8th. I can confirm that in a second, Your Honor. I apologize. Yes, December 8th, 2020. And it consists of 12 pages and 2 attachments, GAW3R and GAW4R.
PC Exhibit 4 is marked.
And Your Honor, I would ask that the surrebuttal testimony of OPC witness Glenn Watkins filed on December 21st, 2020 be marked as, I believe, OPC Exhibit 5. And that testimony for the record consists of 11 pages plus 2 attachments, GAW5 SR and GAW6 SR.
OPC Exhibit 5 is marked.
Thank you, Your Honor. At this time, I would ask that OPC Exhibits 3 through 5, which are the 3 testimonies filed by OPC witness Glenn Watkins in this matter, be admitted into the record.
By stipulation of the parties, OPC Exhibits 3 through 5 are admitted.
Okay, thank you, Your Honor. Now, I would ask that the direct testimony of OPC witness David Garrett be marked as OPC Exhibit 6.
OPC Exhibit 6 is marked.
And that was filed on November 20th. Bear with me one second, Your Honor. That was filed on November 20th, 2020. And it consists of, I believe, 84 pages, as well as 9 appendices and exhibits DJG1 to DJG18. I would ask, Your Honor, that the rebuttal testimony of OPC witness David Garrett filed on December 8th, 2020 be marked as OPC Exhibit 7.
And that testimony, sorry.
I'm sorry. I apologize, Your Honor.
No, go ahead.
That testimony consists of, I believe, only 6 pages with no exhibits.
OPC Exhibit 7 is marked.
Thank you, Your Honor. And finally, I would ask that the surrebuttal testimony of OPC witness David Garrett be marked as OPC Exhibit 8. And again, that testimony consists of, I believe, 13 pages, also with no appendices or exhibits, and that was filed on December 21st, 2020.
OPC Exhibit 8 is marked.
Thank you, Your Honor. And OPC moves for admission into the record of OPC Exhibits 6 through 8, which are the 3 testimonies filed by OPC Exhibit David Garrett in this matter.
By stipulation of the parties, without objection, OPC Exhibits 6 through 8 are admitted.
And I believe that that's OPC's case, Your Honor. And I believe that's everything for us at this time.
Okay, OPC rests. We'll turn to staff. Does staff have a witness?
Yes, we do, Your Honor, but altering the agenda a little bit, staff would like to move in its stipulated testimony first, if we might.
Go ahead, Mr. Wilson.
Ms. McErlin will enter the testimony of 2 of the witnesses for us.
Go ahead, Ms. McErlin.
Thank you. Your Honor, staff would ask that the correct direct testimony of Negusi Teste filed on November 23rd, 2020 as ML23 and exhibits on behalf of the staff of Maryland Public Service Commission be marked as staff exhibit number 16.
Your Honor, I think that's the very first part of what she said. I'm very sorry. This is.
I apologize.
It's not your fault. Just get a little close and try it again, please.
Okay.
You're kind of cutting in and out.
Okay. Does this sound better?
Let's give it a try. Okay.
Your Honor, staff would ask that the correct direct testimony of Negusi Teste filed on November 23rd, 2020 as ML232694, consisting of 46 pages and exhibits on behalf of the staff of the Maryland Public Service Commission be marked as staff exhibit number 16.
Okay, staff pre-marked that as 14. You want that marked now as staff exhibit 16?
Yes. Or
okay.
no, I guess if it's pre-marked, then we'll stick with 14.
Okay.
14 is right, Your Honor.
Okay.
Okay, so the direct
apologize.
testimony of witness Tesfaye is marked as staff exhibit 14.
Thank you. And that the surrebuttal testimony of Negusi Tesfaye filed on December 21st, 2020, consisting of 9 pages and exhibits as ML number 23304 on behalf of the staff of the Maryland Public Service Commission, pre-marked as staff exhibit number 15, be marked.
Staff exhibit 15 is marked.
And Your Honor, staff would like to enter into the record the corrected direct testimony of Olivia Kukendile filed on December 3rd, 2020, consisting of 22 pages and exhibits as ML 232824 on behalf of the staff of the Maryland Public Service Commission as pre-marked staff exhibit number 17.
I think it was pre-marked as staff exhibit 16, so the corrected direct testimony of witness Kukendall will be marked in the record as staff exhibit 16.
Thank you, Your Honor. And then, Your Honor, staff would like to enter into the record their surrebuttal testimony of Olivia Kukendile filed on December 21st, 2020, consisting of 15 pages and exhibits as ML 233044 on behalf of the staff of the Maryland Public Service Commission as pre-marked staff exhibit 17?
17, correct.
Okay.
Staff exhibit 17 is marked.
Thank you, Your Honor. And staff moves for the admission of staff exhibits 14 through 17 to be entered into the record, please.
Without objection and by stipulation of the parties, staff exhibits 14, 15, 16, and 17 are admitted.
Thank you.
Thank you, Your Honor. And while we're about the stipulated testimony, staff and I believe Your Honor and all parties received from Mr. Dodge during the last testimony about 15 minutes ago, a notice that WGL has no cross for staff witness Afton Hauer. I haven't had a chance to poll the other parties. I wondered if we could do that now to determine whether Ms. Hauer's testimony is right to be submitted at this time.
You're gonna have to give me a minute. Just give me about 2 minutes, okay?
Sure.
Thank you. All right, does any party have cross-examination for staff witness Howard?
No. No, Your Honor.
No, Your Honor.
No, Your Honor.
Staff witness Howard can be released. And Mr. Wolfson, do you have some testimony that needs to be marked at this time?
I do, Your Honor. If you could mark as Staff Exhibit 18, the pre-filed direct testimony of Afton Howard with exhibits, which was filed on 11/20/2020 as mail log 232685.
Staff Exhibit 18 is marked.
If you could also mark as Staff Exhibit 19, the pre-filed rebuttal testimony of Afton Howard with exhibits filed on 12/08/20 as mail log 232881.
Yes, staff pre-filed rebuttal testimony of witness Howard is marked as Staff Exhibit 19.
And staff, if we could pre-mark staff, if we could mark for identification, Staff Exhibit 20, the surrebuttal testimony of Afton Howard filed on 12/21/2020 as mail log 233044.
Sir, rebuttal testimony of staff witness Howard is marked as staff exhibit 20.
With that, Your Honor, I would move into evidence staff exhibit 18, staff exhibit 19, and staff exhibit 20.
Without objection and by stipulation of the parties, staff exhibits 18, 19, and 20 are admitted.
And staff, if it's meets with Your Honor's approval, we'll call to the stand staff witness David Valcarengi.
Mr. Valcarengi, will you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Mr. Wilson, you're a witness.
Thank you, Your Honor. Good afternoon, Mr. Valcarengi.
Good afternoon.
Could you state for the record your business address and your position with the commission?
The business address is 6 St. Paul Street, Baltimore, Maryland, 21202, I believe. I serve as the Assistant Director of the Accounting Investigations Division.
Okay, and in that capacity, did you produce and cause to be filed direct testimony, rebuttal testimony, and surrebuttal testimony in this case?
I did.
And do you have before you what has been pre-marked as staff exhibit 11, which is the direct testimony of David Valcarengi with exhibits mail log 232685, filed on 11/20/2020. Staff pre-marked staff exhibit 12, the rebuttal testimony of David Valcarengi with exhibits mail log 232881, filed on 12/08/2020, and staff exhibit 13, the surrebuttal testimony David Valcarengi with exhibits mail log 233044, filed on 12/21/2020. Do you have that before you?
Yes, I had them.
And do you have any, and Your Honor, may they be so marked?
Yes, staff exhibits 11, 12, and 13 are marked.
Yes. And do you have any corrections to any of those sets of testimony?
Yes, starting in the direct testimony.
Yes.
There are two sets of cover pages which are labeled exhibit DLV-2. The second page was included erroneously and should just be excluded from the package. So the page of exhibit DLV-2, which find data responses ending in the 5-2024 is the appropriate cover sheet for exhibit DLV-2. And then in the rebuttal testimony at page 5,
and that's exhibit 12. Yes.
On line 2, there should be a period after the word included, and then the balance of that sentence, and then the next sentence after should be stricken. And then farther down on line 7, see STIDE, that should be stride, STRIDE. Those complete the balances of corrections to my pre-filed testimonies.
Okay. Taking into account those corrections, do these documents, as corrected, comprise your sworn testimony in this case?
Yes, it does.
And as corrected, are they now true and correct to the best of your knowledge, information, and belief?
Yes.
Your Honor, I would move into evidence staff exhibits 11, 12, and 13.
No objections, Your Honor.
Objections?
No objection.
Staff exhibits 11, 12, and 13 are admitted.
And with that, Your Honor, I would offer the witness for cross-examination.
Sounds like Mr. Buckley, you're on deck for WGL. I'll return to WGL for cross.
Guilty as charged, Your Honor. Thank you. Hello, Mr. Valcarengi. It's been quite some time. It's good to see you.
Good afternoon.
I'd like to start, please. Let me just make sure I got your first correction or one of your corrections correct.
The first correction was eliminating, there's 2 cover pages marked as Exhibit DLV-2.
And that's what I'm looking at. So my document only has 1 cover page. So I guess somebody had appropriately did it. How many documents is listed on it? Is it 9 or more on the one that you want retained?
Hold on 1 second.
Because actually I now see a second page. So there's 2 pages. One has 9 data responses and the other has 14.
The appropriate cover sheet should have 9 marked responses from the company.
Great. I got it. Thank you. Let's start with marketing expenses, Mr. Valcarengi. It's fairly clear reading your direct and your serve rebuttal testimony that you still object to the inclusion of the company's roughly $590,000 of test year marketing expenses, correct?
I do.
So accountants love their ledgers. So what I'd like to do is I'd like to walk through with you, please, a couple of your objections on one side of the ledger, and let's see if we can summarize before we start talking about some of the other evidence related to what the company believes justifies inclusions. You with me?
Excuse me, yes.
So just again at a high level, and we can go page by page if you wish, but just at a high level on the side of the ledger where you're relying on material to exclude these costs, you are saying that the company hasn't provided, your words, the crucial determinant that there is a connection between the expenditures and the acquisition of customers. Do I understand that correct?
Yes, that's correct. I mean, what I would say, you heard Ms. Frazzini, I believe on Friday, she said there's no way to earmark the expenditures for promotional advertising to the acquisition of customers. That's in the record in this proceeding.
So 2 comments, Mr. Valcarengi. First of all, you set a world record for getting an expert witness's speech on the thing. I only asked you if it was the grounds for your exclusion. So you got your speech in about Ms. Frazzini, but secondly, I do disagree with your characterization. On the left-hand side of the ledger, sir, you also cite 3 different Maryland utilities as not seeking recovery of those expenses in support of your exclusion. Do you not?
I can't remember the exact utilities. You want me to go and pinpoint them in my testimony, but I did earmark a number of utilities that do not recover promotional advertising costs in the development of the revenue requirement.
We can keep it moving along. Would you accept, subject to check, that you cite Pepco, BG&E, and Columbia of Maryland?
Yes.
So on the right-hand side of the ledger, well, are there any other arguments other than the fact that you believe the company hasn't identified that crucial determinant and that other Maryland utilities, in your mind, these 3 Maryland utilities don't collect the same? Are there any other arguments that you can think of off the top of your head that you provide as your basis for exclusion?
Well, yeah, one of the most important things is that the company hasn't illuminated the benefits to ratepayers coming from the promotional advertising.
So isn't that just a variation on you suggesting that the company hasn't linked benefits to the expenditures, or are you saying that as a different argument?
Can you say that again, Mr. Buckley?
Let's try it this way, Mr. Valcarengi, because there's going to be a good number of questions on it later. There is a good deal of testimony and a lot of material in past commission orders related to the fact that acquired customers by the company, new customers, because of the line extension policy of the commission and the company's tariff, produce tens of millions of dollars of long-term net benefits to the system. You understand that, correct?
I would agree that customers added to the system provide benefits to customers overall. But what the distinction here is that the company has not established that the customers acquired and connected to the system were done as part of the promotional advertising campaign. There's nothing in the record. And the company has done nothing to demonstrate that. I think there was a number of 5,300 or 5,900 customers that were added during the test year. The company has not demonstrated that any of those customers were added to the advertising campaign. I think Ms. Grazzini indicated that the promotional advertising campaign is I think her words was a first line, and that benefits bestow sometime after that. But there's nothing to suggest how many customers are connected pursuant to the program.
So you're jumping way ahead. I'm simply trying to understand which arguments you're making. So you definitely make, so let's go ahead and do it then. We'll go ahead and go through your testimonies. Before I start this, Your Honor, again, I think we have identified a workaround so that I can share documents and work through them. I'll make an attempt. If I can't do it, we can certainly walk through orally like Mr. Dodge did. So let me give it a swing.
Thank you.
And of course, it comes up with a completely different instruction than it did during our test runs.
Maybe I can help you out, Mr. Buckley.
Well, okay. I'm looking for. Let me try it real quick. Let me see if it's just giving me an extra screen, and then I can.
Sure, no problem. Take your time.
That's the wrong one. Okay, I'm afraid I'm going to need your assistance. This grumbling is in there, and it won't let me load my documents. So I'm simply looking at Mr. Valcarengi's direct testimony at page 29.
Yeah, I think I'm there.
Thank you. You see that, Mr. Valcarengi?
I do.
At line 7 there, your testimony states that it can't be discerned how the amount spent lead to increased sales. That's a summary of what you just said a few moments ago, correct? About the connection between the expenditures and the increased sales?
Yes.
So how is that? And I recognize that you say that consistently in your direct testimony and your survey rebuttal testimony. You would, when I asked if that was the primary thrust of your opposition to the recovery of the expenses, in addition to the statement that other utilities don't collect it, you offered what sounded like another third argument against it. Can you describe that for us and show us where that is in your testimony?
Another third argument. My testimony is that the company's claim of promotional advertising expenses, there are no direct ties to benefits from that program, which is what I'm saying here on line 7.
And I understand. So that's the primary argument you're making, and your secondary argument is that other Maryland utilities don't seek to collect it. So do I have both arguments? Those are your two primary arguments, correct?
I think those are the only arguments I'm making.
Thank you. Your Honor, and I hate to ask you to do this because we have probably 4 other documents. Could you bring up Ms. Frazzini's rebuttal testimony? And that would be Washington Gas Exhibit 18, which was originally marked as Q, as in Quebec. Thank you, Your Honor. I'm looking specifically at the end of the testimony, pages 16 through 17. Do you see those pages, Mr. Valcarengi?
I remember reading this.
So at the end of the testimony, this is a summary of different arguments made by Ms. Frazzini in response to some of your arguments, as well as it's the company's basic case to the commission. There's certainly a lot more information, data responses, and the like. But let's just walk through a few of those and make sure that you understand that these are arguments the company has made, and I'm going to be walking through a few of them with you. For the first one you see there at lines 18 through 19, a benefit that the company states is in the directly benefits customers and is in the public interest, provides valuable information regarding comparative energy costs and environmental impacts. Do you see that, sir?
I do.
So can you, off the top of your head, tell us or identify for us in your testimony where you challenged that material provides a direct benefit and is in the public interest?
Well, you're flipping it on me, Counselor. It's not my job to point that out. It's the company's job to point out how the program provides direct benefits. Merely providing a summary of how a promotional advertising campaign, I think these allude to it's in the public interest. They in no way discern how the program provides direct benefits.
So let's break this down for just a second, Mr. Valcarengi, because that's a very critical point, and I believe you have read past commission cases on the recovery of marketing expenses. The summary points at the bottom of this page, continuing on to the next, there's 4 points provided. The bottom 3 all relate to direct economic benefits to customers that are also in the public interests. And those are discussed extensively both by you and Ms. Frazzini. I'm focusing on this first point, that providing valuable information in a competitive market regarding comparative energy costs and environmental impacts in and of itself provides a direct benefit and is in the public interest, an independent basis for providing approval of these costs. So can you tell me in your testimonies where you have challenged the testimony of Ms. Frazzini that these provide a direct benefit and are in the public interest?
Well, again, I think this statement is vague. It doesn't correlate back to the dollars in question. There's no way to say that the promotional advertising expenses in question were directly attributable to the acquisition of customers or increased sales. That, in my mind, is that's the direct benefit. That's how you know that the promotional are meeting the mark consistent with the COMAR standard.
So Mr. Valcarengi, you may not have heard me clearly, or maybe I wasn't clear enough. I'm not suggesting that this first bullet is tied to the economic benefits that are provided elsewhere and discussed elsewhere in Ms. Frazzini's testimony. This is talking about the benefits to customers related to the information in a competitive market on comparative energy cost, environmental impacts, and other information that allows customers to make wise energy choices.
Objection, Your Honor. This has been asked and answered twice already.
Well, I'm happy to move on. Mr. Valcarengi's response switched into economics material, so we'll move on.
Again, this highlighted passage is vague. It doesn't correlate into specific benefits.
So, Your Honor, with your indulgence, could I ask you to switch exhibits? Washington Gas Exhibit GG, which is a 2003 Washington Gas rate case. So you're right, you're in HH right now. Well, I thought you were, because it looked like that was the 9481 case. Whoops, you're in it. We may have a no, that's it. Okay. So, Mr. Valcarengi, you do recognize this commission order from then examiner Alan Freifeld?
I do, but this is prior to the commission's order in case number 9481, wherein the commission said they wanted an enunciation of how it met the standard consistent with COMAR. This is clearly before that case.
I hear you. So let's just step through this order, and then we'll get to that we'll get to the 2018 order as well. So, okay. Your Honor, with your indulgence, could I get you turn, please, to page 41 of Mr. Freifeld's order? And before we get there, Mr. Valcarengi, you are familiar with Alan Freifeld, are you not? The long-term staff counsel, hearing examiner, and then ultimately commissioner?
Yes, I am familiar with Commissioner Freifeld.
And you recognize that he was a very experienced practitioner, a well-recognized rate-making expert, and also an expert on Public Service Commission precedent. Do you recognize him as such?
Well, his qualifications speak for the... As I indicated previously, his order is clearly before the commission's order in one. So clearly the
understood. So are you suggesting that Commissioner Freifeld is not a well-respected rate-making expert?
No, I never said anything of the sort. All I'm suggesting is the commission's order in 9481 was clearly after the order issued by Commissioner Freifeld.
And we'll take it in order. Do you see there in the middle of the page, Examiner Freifeld's finding that the company has presented extensive testimony regarding the marketing function and marketing programs. The testimony establishes that the marketing function benefits customers in at least two distinct fashions, and I find the company's evidence persuasive. The first of those findings, Mr. Valcarengi, is summarized in the next paragraph, where he finds that the marketing expenditures are necessary and proper expenses which benefit customers. The provision of the information is in and of itself, so that's not tied to the economic benefits. The energy education information is in and of itself beneficial to customers and potential customers who can evaluate the information provided by the company, and that by provided by competing energy sources, and can then make an informed decision. Do you see that, sir?
I see the highlighted passage, Mr. Buckley.
And do you recognize then that Examiner Freifeld in 2003, I know it's before 2018, but in 2003, he made an independent finding that the provision of that information in and of itself was a direct benefit to customers and was in the public interest?
Well, the order says what it says, but it also
it's either a yes or no, and you can explain it as you wish. Do you recognize that finding by Examiner Freifeld? And then feel free to explain it away if you wish.
The order says what it says, Mr. Buckley. I mean, it also says that there was an persuasive provided. As I sit here today, I don't know what evidence was provided. But I go back to the order in 9481, where the commission said they wanted more information that discerned the benefits pursuant to this program.
It's going to be a little cumbersome, Your Honor, but to satisfy Mr. Valcarengi, we're going to jump back and forth between the two orders. So if I could, with Your Honor's indulgence, if I could ask you to switch, please, to order, WG Exhibit HH, which is the Commission's order in 9481.
So on the specific document, it's GG, but it may be HEH, but I think I'm on the right thing. It's 9481, order number 88844.
You are, and thank you. And I'm looking at page, well, first of all, Mr. Valcarengi, you recognize this order. This is the order you're making reference to about the Commission's most recent litigated determination?
Yes, with respect to Washington Gas and promotional advertising expenses.
Thank you. Page 80, Your Honor, if you will. So as a preliminary, Mr. Valcarengi, were you listening to Ms. Frazzini's testimony yesterday, particularly when during redirect testimony, when I asked her some questions regarding the COMAR provision and the use of the word informational advertising versus information contained in promotional advertising?
I remember Ms. Frazzini's testimony, but I can't recall the specific line of questions that you're dovetailing on.
Sure. And to try and shortcut it, I'll ask you to accept it subject to check, and we can go through her testimony and I can show you where I led her. However, there's a distinction. There is a specific COMAR provision related to informational advertising, and that has been defined as things such as call misutility, call 811 before you dig, hearing examiner notices, hearing notices, and the like. Do you understand that small category of informational advertising, which your testimony does not challenge?
Yes, I agree that I think there's 3 levels of advertising expenses. Informational, promotional, and I think the other is institutional.
Yeah, it's not a pop quiz, but I think there may be 4. But the point of this, for getting to this 9481, is so there is a, again, I'll use with Ms. Frazzini, capital I informational related to call misutility, specific information that's related to the regulatory process and the operations of the utility itself, hearing notices and dial 811. And those are not being challenged by you, correct?
That's correct.
Now, I spent a good deal of time with Ms. Frazzini, and actually the bulk of her testimonies relate to the information, small letter I, that's contained in the promotional advertising that provides information such as Examiner Freifeld referenced, and it's extensively in her testimony, comparative energy costs, conservation tips, environmental benefits of using natural gas. So do you understand that distinction on information?
I don't understand the point you're trying to make here, Mr. Buckley.
I'm simply asking.
The promotional advertising expenses are actually informational in nature? Is that where you're going?
That's what Ms. Frazzini's testimony states extensively, yes. It's not that it satisfies that category informational, but the justification for why it's a direct benefit and in the public interest is that it's providing valuable information to allow customers to make wise energy choices. And do you recall Ms. Frazzini's testimony discussing that extensively?
I recall that testimony, but that dovetails into the point I was mentioning earlier, that if you go back, there was a number, I can't remember the specific number, 5,300, 5,900 customers were connected to the system during the test year. It is impossible to discern how many of those specific customers connected to the system related to the promotional advertising campaign.
So we are absolutely talking across each other, Mr. Valcarengi. I would ask you to listen to me carefully. When I'm speaking here about the information that Ms. Frazzini's testimony discusses extensively about educating those customers to make wise decisions, it is not the same as her testimony where she's talking about how that information has led customers to make a switch to Washington Gas and thereby provide economic benefits. Mr. Freifeld's proposed order, and we'll show in this testimony, this language from the commission in 9481, says that the provision of that information to educate customers and help them make wise decision is in and of itself a direct benefit in the public interest. Do you understand that distinction?
Well, I understand the distinction, but I go back to my earlier testimony where I say, again, there's 5,900 customers. If you're providing information ostensibly to assist in the connection of those customers, we should be able to see that. There's no information that has been provided to show that a certain bank of customers connected pursuant to the program.
So I'm asking you to focus on the information itself and a commission finding. So let's, Your Honor, if I get you to scroll the screen up a little bit with the paragraph beginning WGLs. Oh no, on that same page 80. There you go. WGL advertising campaigns. It's a long quote, Mr. Valcarengi, but please be mindful that in this entire paragraph where the commission is making a finding that there's a direct benefit, there's no mention of the 6,000 customers that signed up to natural gas. There's no mention of the amount of money of net present values that was given to the benefit of ratepayers. This is the information itself. It states that that Washington Gas's advertising campaigns include a substantial amount of informational advertising. These include programs to educate customers about the environmental benefits and the energy savings of natural gas appliances, as testified by Ms. Johnson. Would you agree that that same information related to environmental benefits and energy savings is also included in the testimony of Ms. Frazzini? If you know. If you can't confirm,
lead you to the line that's right at the bottom of the page where it says those types of advertising must provide a direct benefit to the ratepayer and be
sure,
in the public interest.
But let's go up to the previous finding. These types of programs are informational and presumed to be in the public interest, and the commission so finds. The line you were referencing to was when the commission jumped to other forms of advertising. So I'm just talking in the top part of that paragraph on the educational information being provided to customers so that they can make wise energy choices. The commission itself, just in 2018, concluded, just like Examiner Freifeld did.
Your Honor, I'm going to have to object. Mr. Buckley is continually testifying himself. If he wants to ask about a specific quotation, that's fine. But we're getting argument and editorial preambles before his questions.
I'm happy to rephrase, Your Honor. So on that top part of the paragraph, Mr. Valcarengi, the commission identifies educational materials to customers related to environmental benefits and energy savings, correct?
Is that on the line before this one?
It's currently highlighted by the examiner, by the judge.
But I think the problem here is you read this passage of the order, it is relating to, again, there's multiple categories of advertising expenses. I read this to, it's regarding those that are couched as informational in nature.
So I asked you earlier if you understood the distinction between information, capital I, which were the things like call 811, and you said you understood that distinction. I also asked you if you understood that Ms. Frazzini's testimony included a great deal of information to educate customers about environmental benefits and energy savings, and you said you recognized that distinction. Do you now not recognize that distinction?
Objection. He's arguing with the witness.
Well,
Sustained.
Thank you, Your Honor. I just simply want you to understand, Mr. Valcarengi, let me ask if you'll acknowledge, and feel free to answer and distinguish it as you wish. At the middle of the paragraph, another full sentence down, 2 sentences down, the statement starts, these types of programs are informational and presumed to be in the public interest, and the commission show finds. Can you identify that description anywhere in that top part of the paragraph that relates to either a customer switching or the economic benefits that relate to the net present value?
I'm not sure I understand your.
Sure. So the commission statement right there says these types of programs. It only identifies 2 types of programs right above that, correct?
Well, yes, but Then you go farther down where the commission in the order says must provide a direct benefit to ratepayers and be in the public interest, or they are excluded.
Your Honor, I'd like to move on. Let's go to Mr. Valcarengi's direct testimony at page 29. And there will be, unfortunately, Your Honor, a jumping between a couple of different documents with the next line of questions.
Which documents do you need? I'm gonna pre-prepare them for you.
Sure. This is
I think I'm there at direct 29.
and you are. Thank you. Mr. Valcarengi, I'd like to direct your attentions to your testimony there at between lines 6 through 8. Do you see that, sir?
I see it.
Now, before we go through the couple of sentences, you also prepared testimony in the company's preceding base rate case, did you not? That's case 9605, also on the marketing expenses?
Yes, I did.
So here in case 9651, you state in response to a question about, and you mentioned it earlier, about illuminating benefits, in response to a question about has the company effectively illuminated or described the benefits, you say no. It is difficult, if not impossible, to assess the benefits of the promotional advertising campaign. You then go on to say it cannot be discerned how the amount spent lead to increased sales. Do you see that, sir?
That's what the testimony says.
And Your Honor, I'd like to ask that we move to a different exhibit. This is going to be Washington Gas exhibit. I have it as letter II. It may be double H in your packets. It's Mr. Valcarengi's testimony in 9605. And do you see that, sir, that testimony, sir? This was your testimony that you drafted and filed in case 9605?
Yes.
And is the information in that testimony, as you recall it, accurate and remain accurate today? And that was basically filed essentially 1 year prior, correct? Washington Gas has had rate cases in consecutive years.
That's correct.
Your Honor, if I could get you to turn, please, to page 32 of Mr. Valcarengi's direct testimony in 9605.
You said page 32?
Yes, 32. And Your Honor, unlike the orders, and I forgot to ask for this instruction, but unlike referencing orders, which Washington Gas does not normally seek to have identified or moved into the record, I am going to ask that Mr. Valcarengi's direct testimony in 9605 be marked for identification purposes.
Are we on WGL 31? Do I have that right?
That's not the number I have, but I bet your list is a heck of a lot more accurate than mine.
I believe it is 31.
Okay.
Thank you, Mr. Dodge. WGL Exhibit 31 is going to consist of Mr. Valcarenzi's direct testimony in case 9605. It's so marked.
Thank you, Your Honor. Specifically at page 30, that's where the marketing material starts, Mr. Valcarengi. Do you recall that testimony? Okay, if I can get you to turn, please, to the next page, Your Honor. Specifically at lines 11 through 16. So, Mr. Valcarengi, this isn't a criticism. We all make extensive use of word processing. And so essentially what you've done is taken the same question in the current case about whether the company has done an effective job of illuminating the benefits, and you provide your answer 1 year before this case, correct?
Is there a question to me?
So you're answering the same question that you answered in the current case, 9651. Does the company do an effective job of illuminating the direct benefits? And Mr. Valcrengi, this isn't a criticism. All of us use word processing. All of us cut and paste and edit as necessary. So is that the same question you've asked in this case?
Yeah, I mean, the response is a little bit different in the pre-filed materials I filed in this case than what I wrote in the prior case, 9605. Here in the testimony before you, I discuss how it's related to particular classes. In the testimony that I have in this record, I simply say you can't discern a benefit. And I remove the distinction to particular classes. I don't know that point is the point is still the same, that if there are any to promotional advertising, you can't see how they are attached to connections or increased sales that may have transpired.
Again, thank you for that answer, and you're jumping ahead. That's one of the two important differences in that testimony. There's another important difference, Mr. Valcrengi.
Objection. Is this a question, or are you just going to testify?
Well, the Mr. Wilson, and I'll ask for this instruction through the bench. Mr. Valcrengi's answer wasn't responsive to the question. He jumped ahead and provided a defense on something that wasn't being asked about. So I'm simply putting it in context and trying to redirect him back to where we can ask questions. So let me try it this way. Mr. Valcrengi, if you would refresh your recollection, let's start on line 11. The answer to that same question from 9651, asked a year prior, you say no. It is difficult, if not impossible, to assess the benefits of the promotional program on particular classes. And that's where you indicated one change. You didn't use the word particular classes in the current case, right?
Yes, as I testified earlier, I did not make that distinction in the testimony that I provided in this case. As I indicated earlier, I don't know that makes a distinction, because you can't discern the benefits pursuant to the program.
So continuing on, Mr. Valcrengi, do you see there at line 13, you, however, do say that there is a discernible benefit applicable to the cost incurred, is that the promotional campaign was victorious, your words, in connecting on average 6,000 customers per year, which produced an average annual net present value of approximately 23 million. That testimony states that there was a discernible benefit, does it not?
That's what the passage says, but
Then well, go ahead, please, if you have something else you want to explain.
It's a summary of the company's point with respect to what they do. My point is, of those 6,000 customers, you can't tell how many customers or what level of increased sales are determinant related to the promotional advertising campaign.
So this is your testimony, Mr. Valcrengi. At line 13, you do state in that sentence that the acquisition of those 6,000 customers is a discernible benefit.
Well, this is, if you see at the end of that sentence, it's footnoted to Ms. Johnson's testimony back in 9605. Again, this is a summary of the company's point. And this harkens back to the point that I've been discussing, is that it was 6,000 there. It's 50, I think either 5,300 or 5,900 customers. The point I'm trying to make is that you can't tell how many of those customers connected to the system with pursuant to the promotional advertising campaign.
So we're going to flip back in that testimony for just a minute. I'm going to do one minor correction on your testimony, if you will. And You can feel free to accept it or not. First, so we are in the, I'm sorry, did we get back to the pagination has moved from me, Your Honor. Are you in 9651 version or the 9605?
Which case do you want me in?
I want the 9651.
We're there. What page?
You're right there. So
Okay.
this is just a simple correction, Mr. Valcarengi. Do you see at line 12 where you have the $23 million reference?
I do.
That's just the cut and paste from the prior case. Would you accept, subjected to it, to check that Ms. Frazzini's testimony actually states that the test year acquisition of 5,700 customers produces a net present value of approximately $20 million, not 23?
I'll accept that subject to check. I don't know that it changes the substance of the testimony, though.
It really doesn't. So let's talk about that. Let's talk about those amounts of money and the source of them and what the benefits are to the system real quick. First of all, are you familiar with the Commission's line extension policies and the company's tariff, GSP 14, that it provides an analysis of new customers and whether or not they provide an economic benefit to the system?
I am generally aware of the GSP 14. I can't say I have intimate knowledge of all of the standards that go into GSP 14.
So, and again, we're just talking about what the value of whether it's the 23 million for an average number of years or 20 million for this current test year. Do you understand or recognize that the GSP 14 provides a calculation to assure that new customers produce a rate of return equal to or above the Commission's authorized return?
Well, I believe that is the standard, but that goes back to my point. I see the number, the NPV of whether it's 20 or 23 million. What you don't know, this is describing an NPV of customers that were connected to the system. Again, you can't, there's no information that has been provided that will discern how many of those customers were specifically tied to the system related to the promotional advertising campaign.
Yep. Mr. Valcarengi, you've made that point over and over again. I'm simply asking you about the derivation of that number and if you understand what it means without arguing about whether or not the marketing expenses caused it. So let me ask the question again.
Yes, the net present value equates to essentially, I think it looks over a period of 30 years using the capital costs as the capital costs and the expenses related to the acquisition of a particular customer based on the company's rate of return as provided by the Commission.
Close enough. So in essence, in summary of that, and again, I know you distinguish whether or not the advertising costs are directly, or as your phrase, a crucial determinant to them being added to the system, but the amount of dollars that test indicates, it's a long-term benefit just for those test year customers. $20 million in today's dollars will be added, and all customers on the Washington Gas system will be getting a benefit from that. Correct? Do you agree?
I don't dispute that the NPV provides a demonstration of benefits. The problem you run into is how that is delineated into the promotional advertising. Those customers presumably could have connected to the system. Promotional advertising expenses.
So I understand that point. You're making it repeatedly this morning. I'm simply trying to identify what are benefits to the customers, whether or not you think the advertising expenditures led to those benefits is an entirely different question. So you recognize, though, that the addition of these roughly 6,000 customers is a direct benefit, correct?
Well, sure. Adding customers to the system, if they are done in a responsible manner, provides benefit to the system. You have additional customers, presumably you have additional sales. That would benefit the system.
And again, in the same vein, with your understanding of your disagreeing that the company's marketing expenditures are the crucial determinant, the addition of customers, which leads to a more efficient utilization of the system, also provides a direct benefit to existing customers, correct?
Well, sure. I would agree that to the extent the system is if customers use gas more efficiently, that would be a benefit. But again, I go back to the point that I've been stressing is you can't earmark that back to the promotional advertising campaign.
Your Honor, if I could ask for your indulgence, because we are jumping around a little bit, and I apologize for that. Could I get you please to go back to the proposed order of Alan Freifeld in case 8959? I believe it's Exhibit GG, but I think you may have it as HH. Yeah, that's correct. Page 42 of that order, if you would, Your Honor. Right there is fine. Thank you. So again, Mr. Valcarengi, we're talking about the 2003 findings from Examiner Freifeld. Again, it's before the 2018 case. Feel free to jump in and explain that again if you wish. I'm focusing on this first full paragraph in the order, and where Examiner Freifeld concludes that it would be wrong to include in rates the sales growth which occurs from year to year, yet to exclude from rates the marketing expense which generated sales growth, as suggested by then the challenge was from People's Counsel. This would be precisely the type of mismatch between revenue and expense which proper rate making seeks to avoid. Do you see that, sir?
I do see that.
So essentially what Mr. Freifeld's saying, and I'm asking you if you agree with it, that by taking the benefits from the $20 million of net present value, but denying the company the recovery of the marketing expenses, that's a mismatch and that's an inappropriate application of rate-making principles. Do you agree with that concept?
I don't think that's what that passage states, Counselor.
Fine. Let's turn, please, if we could, Your Honor. Your Honor, I would like to ask you to bring up, if you could please, this is company witness for Zini's serve rebuttal testimony. And while we're doing that, Your Honor, I would like to ask that the document that's been marked for identification purposes as Company Exhibit 31 That was Mr. Valcarengi's testimony in 9605, be admitted into evidence for the limited purpose of comparing and referencing Mr. Valcarengi's testimony on marketing expenses in that case.
Any objection to WGL Exhibit 31? Hearing none, WGL Exhibit 31 is admitted. Mr. Buckley, you're asking for Ms. Rosini's, which one?
This is her SIR rebuttal testimony, and I believe that that is Exhibit 18. I hope.
That is what I have, Your Honor.
Page 8, Your Honor, when we get there.
Rebuttal, not SIR rebuttal, correct? There was no SIR rebuttal.
Actually, Your Honor, I think I've already got the information I was looking for. I think that that's going to conclude the cross-examination of Mr. Valcarengi.
Okay. Ms. Francis, is there any cross for AOBA?
Yes, Your Honor. I'm just trying to get back on video.
Sure, go ahead, Ms. Francis, whenever you're ready. Take your time.
Okay. Good afternoon, Mr. Valcarengi.
Good afternoon.
I'm going to ask you to start by please turning to page 6 of your rebuttal testimony. Tell me when you're there.
I have it.
Okay. Now, at page 6 of your rebuttal, beginning on line 8, you discuss AOBA witness Bruce Oliver's suggestion that the commission could use financial incentives to assist in controlling Washington Gas's leak management costs, and you characterize his proposal as a two-pronged approach, under which one prong of that approach would require that Washington Gas absorb a percentage of its leak management costs. Is that correct?
That's what I recall Mr. Oliver's testimony to state. Yes.
Okay. Now, I would ask you to please reference page 57 of Mr. Oliver's direct testimony.
His direct testimony?
Correct. Tell me when you have that.
I have it.
Please, let's focus on lines 11 through 21. Just take a moment to refresh your recollection of that.
Ms. Francis, will you give the page and the reference again?
Okay, it's page 57, Your Honor, lines 11 through 21.
Thank you.
Miss Francis, I have it.
Okay. Could you please tell me, does witness Oliver's direct testimony at page 57, lines 11 through 21, contain Mr. Oliver's proposal for control of Washington Gas's leak management cost, to which you responded in your rebuttal testimony at page 6?
Yes.
Now, in the sentence at page 57, lines 15 through 18, let's focus on those lines. Mr. Oliver states, first, Washington Gas could be required to absorb a significant percentage, in other words, 50%, of any increase in leak management safety response costs attributable to further increases in its annual numbers of hazardous leaks, end quote. Do you see that?
Yes, I see that.
Is it your understanding that Mr. Oliver was suggesting in that testimony that Washington Gas should be required to absorb a percentage of the company's total leak management costs, or just a percentage of any increases in leak management costs, safety response costs that the company may occur?
I think he's talking about the incremental cost.
Thank you. Now, please turn to page 7, lines 10 through 13 of your rebuttal testimony. And at page 7, lines 10 through 13, you state, quote, "The commission is exploring the use of incentives on certain initiatives in case number 9618. Although the concept may have merit, the proposal advanced by Mr. Oliver is inadequate in its present form and therefore should be rejected." Do you see that?
I do.
Okay. Now, you suggest that Mr. Oliver's concept may have merit. Do you have a recommendation for the forum in which financial incentives for Washington Gas to control its annual numbers of hazardous leaks and leak management costs could or should be considered, excuse me?
Are you asking me whether I have a recommendation consistent with the proposal that Mr. Oliver put forward?
I guess I'm asking, you suggested that the forum that Mr. Oliver put forward may have merit, but that it wasn't the appropriate forum for that consideration. Do you have?
It's not that it was an inappropriate forum. The problem is the proposal that he laid out is not really flushed out. We don't. I think I tried to glean that in the testimony. We don't know what percentage of cost is going to be excluded. There's a whole set of details that would have to be evaluated in order to determine whether it's an appropriate policy. The other thing is the commission historically hasn't used incentives as a means of evaluating or instituting appropriate behaviors for the utilities under its jurisdiction.
Okay, so and I don't want to misstate what your testimony is. So it's your position now that this rate case is not an inappropriate forum, but that you don't believe Mr. Oliver has enough detail around his proposal to adopt it at this time. Is that what you're saying?
Well, certainly AOBA can put forward any policy that it chooses to. It's difficult to evaluate the proposal as submitted because certain details were not put forward. So you can't evaluate the proposal. One of the things I said in my testimony was in order to properly you're going to have to be able to evaluate.
Your Honor, I'm sorry. Something's happening. I didn't hear his.
And can we repeat that because I lost it too?
I'm sorry. Mr. Valcarenti, I just didn't hear your response. I don't know whether it was my computer or you froze. Could you try that response again? My apologies.
I'm not suggesting that another forum would be better. The problem, as I see it, is that the proposal advanced by AOBA is missing certain details to evaluate the proposal. A certain measure of cost have on the company. What incentives are?
I'm sorry.
Much of,
Hold up. This is court reporter. For some reason, your picture froze and your voice wasn't there. So can you sort of repeat what you said within the last paragraph? Here's what you do.
Try
Get closer to your computer. And speak
This one's not about being close to the computer. You're having some kind of connectivity issue. So try it one more time, and if it doesn't work this time, we can try to take a 5-minute break and disconnect and reconnect. So go ahead and try it one more time, Mr. Valcareggi.
Thank you, Your Honor.
Ms. Francis, my testimony is that certainly any proposal can be advanced in this case. My problem with respect to the proposal put forward by Mr. Oliver is that certain details from the proposal, i.e. what disallowance would be recommended, what incentive would be recommended. Certainly, in order to look at a proposal, you'd have to be able to recognize what impact is it going to have on the company. Put all that in you say all that, and then you dovetail into the committee hasn't used incentive mechanisms as a means of controlling the utility behaviors with respect to certain items in the cost of service.
Have you finished your answer?
I have.
Okay. Is the staff willing to work with AOBA and other parties to further explore Mr. Oliver's concept and develop a productive and implementable incentive mechanism to foster greater control of Washington Gas's leak management costs?
I don't know how to respond to that other than to say, the staff evaluates a number of items for a number of utilities across the board. If there is additional information that AOB certainly staff would look at it. Now, does that mean we would do something within this case? I don't know.
Your Honor, if I may inquire through the bench, that the last little portion of Mr. Valcareggi's answer is the nature of my request for a clarification from Ms. Francis. Is the request that there be further work performed and analyzed for potential recommendations? It's my assumption that AOBA is looking outside of this case afterwards, because there simply is no time left in this proceeding for any further recommendations to be presented, I don't believe.
Ms. Francis, you can respond to that.
It could be either one or both. I was either looking within this case or outside of this case. Does that help you, Mr. Valcareggi?
Well, I don't know how we would do it in this case, as we're on the last day of hearings, and certainly additional information would need to be put forward.
Okay. Mr. Valcareggi, do you have AOBA's Exhibit 8?
Help me with what Exhibit 8 is.
Okay, I was just going to say that. Exhibit 8 was on our exhibit list that was filed on last Wednesday, and it is AOBA's response to staff data request number 1. Your Honor, I would like to have that marked for the record as AOBA Exhibit 8.
AOBA Exhibit 8 is marked. Mr. Valcareggi, do you have that?
I do not have AOBA's responses to the staff data request.
It is marked as an exhibit on the exhibit list. It was submitted with a zip drive on last Wednesday.
Hang on just a moment, Ms. Francis. Mr. Valcareggi, can you see my screen?
I can.
Mr. Valcareggi, thank you, Your Honor. Am I correct that staff submitted a data request to AOPA on this very topic that we're discussing on December 1st of 2020, and AOBA responded on December 8th, 2020?
Yes, that's what the document says.
Am I correct, Mr. Valcareggi, that you were the author of this data request?
Yes.
Now, can I assume that you've read the response to staff data request number 1, question 2?
Yes, I recall reviewing this.
Now, AOPA's response to Part A of staff data request 1-2 presents an example of a 3-tiered mechanism to provide Washington Gas a financial incentive mechanism to encourage greater control by Washington Gas of increases in its leak management costs. Does that type of detail help to address your concerns regarding the suggested mechanism in Witness Oliver's direct testimony?
Well, no, as I indicated earlier, this one of the things that you have to be able to do is ascertain the other side. And by that, I mean, you're coming up with arbitrary numbers as to appropriate, what you determine to be appropriate disallowances. You have to be able to discern what impact, if any, that's going to have on the company.
I guess what I was asking, Mr. Valcareggi, was what was set forth in Part A. Does that give you an idea, or is that the type of, at least some of the detail that you are requiring in order for this commission to have some sort of an incentive mechanism in order to help control Washington Gas's increasing leaks and increasing leak expenses?
Well, again, it's not my testimony to recommend an incentive plan. The point of my testimony was Mr. Oliver's testimony was opaque with respect to certain details to evaluate it. The data response provides, I guess, what I would call examples But I can't, as I sit here, tell you that the percentages, for example, that are highlighted in the response would be appropriate. I haven't done any due diligence in order to make such a determination. Number two is it automatically assumes that a certain level of cost would be, I don't know what you would call it, imprudent, if you will. That's a high bar, and it I don't know, it gets into, I don't know, a complicated area, if you will. It's not, as I stated before, it's not something that the commission has historically done with utility costs and the setting of rates.
At page 7, lines 5 through 7 of your rebuttal testimony, you suggest that it is unclear whether Mr. Oliver is intending his proposed incentive to be in the form of an adder to the company's ROE. Can you please point to any place in Mr. Oliver's direct testimony where Mr. Oliver even mentions the concept of providing an incentive in the form of an adder to the company's ROE?
Well, that's why I said it was unclear. It was unclear to me whether Mr. Oliver was talking about some directed payment that would at certain benchmarks, or whether of
I'm sorry,
an ROE adder.
Valcarengi,
I said that because I'm fading out.
Yeah, you're fading in and out. What we're gonna have to do is we're gonna have to take a 5-minute recess, and we're gonna have to ask you to disconnect and reconnect. Okay? We'll give it a test run when we come back. So let's go off the record. It's 1:42. You know what, Miss Francis, do you mind if we take a slightly longer break that we'll consider a lunch break at this time? Can you earmark where you are in your questioning?
Absolutely no problem, but I will need that exhibit again, so don't put it away.
I won't. Okay. It's 1:42. Let's go ahead and break until 2:15. We'll do it a half an hour lunch break, okay? Hopefully
That's fine.
we'll have better connectivity at that time. And Miss Francis, I'm sorry to interrupt you mid-stride,
No,
but
it's no problem. No problem.
okay. We're off the record.
Thank you.
Thank you.
Off the record, Your Honor.
Mr. Wilson, are you there? Hi, Chris here, Lisa, can you hear me?
I can hear you, Dave.
Thank you.
You need any legal advice, Dave? I'm right here for you.
No, I think I'm.
I might ask you about the Nats
I
acquisition.
hear you, David.
Schwarber?
Poor man's Adam Dunn, I think.
Oh my gosh. Wow, I hadn't heard that.
And we got Josh Bell from the Pirates.
Oh, I saw that. I thought that was a good trade.
Yeah, now we
I
got
think somebody should
two big
move that
lefties in the
Pittsburgh
lineup.
should just be deleted as a franchise.
Not until I visit the park. It looks like a great park.
It is a great park. Mr. Wilson, how are you?
I'm good. How about you, Dave? What have you been doing today?
Happy to be here. Do all I can for the team.
Hey, Dave, this is Drew. If you turn off your video, the audio should work fine. If you're having trouble again, I don't know if the judge will allow you to do that, but that usually seems to work.
The chairman has done that in a number of other hearings, and it's worked.
We'll see. I went out and came back in. We'll see if reconnecting does anything.
I can hear, Dave, I can hear you now. It's just that sometimes in the middle of a sentence, your frame would freeze and then we couldn't hear anything.
Oh.
Seems to be better now, and it seems like we have everyone. So let's go back on the record.
We're on the record, Your Honor.
Thank you. Ms. Francis, you were in the middle of cross-examination when I so rudely interrupted you. Go ahead.
No, you didn't. I'm going to repeat what I think was my last question. Okay. So if you answered this already, Mr. Valencarengi, I might not have heard your answer. At page 7, lines 5 through 7 of your rebuttal testimony, you suggest that it is unclear whether Mr. Oliver is intending his proposed incentive to be in the form of an adder to the company's ROE. Could you please take a moment, look at the part of Mr. Oliver's testimony that you reviewed, and can you point to any place in Mr. Oliver's direct testimony where he even mentions the concept of providing an incentive in the form of an adder to the company's ROE?
Mr. Oliver does not discuss that. And the reason I placed that in my testimony, that portion of his proposal, in my mind, I thought it was unclear whether he was talking about directed payments pursuant to a benchmark. That's why I wrote that. Because financial incentives can be delivered in a number of ways, i.e. direct benefits or an adder as two options.
Now, would you please turn to page 5 of Mr. Oliver's surrebuttal testimony? Excuse me, let's start with page 4.
I have it.
Okay, now take a look at his chart, his figure 1, to refresh your recollection. Do you challenge the accuracy of the information regarding the annual numbers of hazardous leaks on Washington Gas's Maryland distribution system that are presented in Figure 1 on page 4 of witness Bruce Oliver's rebuttal testimony?
No, and in my testimony, I haven't challenged Mr. Oliver's. It's quite clear that the number of leaks and the cost of the leaks have gone up over time.
Now, just for a moment, take a look at Figure 2 on page 5 of Mr. Oliver's rebuttal testimony, which deals with the increases in leak management expenses by year. Do you believe that the increases, do you agree that the increases in Washington Gas's leak management expenses in recent years have been a major driver of overall increases in the company's annual O&M costs?
Well, certainly the elevation in cost is a driver. I'm having difficulty with the word significant. I think in my mind, the capital costs are the bigger or more significant factor driving cases.
But you do agree that the leak management expenses in the most recent years have been a driver of the overall increases in the company's annual O&M costs, correct?
I would agree that leak management costs are but one of many costs in the cost of service and are factored in the development of rates.
Now, in fact, if you take a look at Figure 2 and you take a look at the footnote on page 4 of Mr. Oliver's rebuttal, you see that the data presented in Figure 2 was based on Washington Gas's response to staff data request 410, correct?
I what the document says.
Do you dispute that?
No, Mr. Oliver's testimony in regard to either the number of or the cost of leak management costs.
What recommendations have been presented by the staff in this proceeding for gaining better control of the substantial increases that have been experienced in both annual numbers of hazardous leaks and leak management costs for Washington Gas in Maryland?
I need that question again, please.
What recommendations have been presented by the staff, in this case, for gaining better control of the substantial increases that have been experienced in both the annual numbers of hazardous leaks and leak management costs for the Washington Gas system in Maryland?
Well, we haven't put forward a recommendation suggesting that what's out there is the cost and the test year are inappropriate, other than the specific recommendation I have to recognize the credits pursuant to paragraph 11B from case number 9449.
Does the commission and the staff have any responsibility to find a solution to the growing number of hazardous leaks and the growing level of increases in costs of leak management costs?
I'm an accountant by trade.
Your Honor, I can't.
Can you hear me now?
Could you start your answer again? You froze.
I started off by saying I certainly can't speak on behalf of the commission. I'm an accountant by trade. Largely, the leak management costs are an engineering issue. I think Mr. Tesfaye did not question nor deem the engineering practices to be imprudent. So in that regard, there's nothing for me as an accountant to fall going to say that a certain element of WGL's cost should be eliminated during this particular case. I haven't seen that I would grant you that leak management costs continue to rise, but we haven't seen anything that would label the costs to be imprudent.
So are you saying that given the company's application and testimony in this case, you don't think that the staff has a responsibility to find a solution to the growing number of hazardous leaks and likewise the growing number of growing leak management costs?
Objection, Your Honor, to the extent it calls for a legal conclusion about what legal responsibilities the staff might have.
Your Honor, I didn't ask for a legal conclusion. Mr. Valcarengi has been with the staff a long time. He is clearly an expert witness. He's been in just about every rate case I've been in over the last many years. I am not asking for a legal opinion. I'm asking in his expert opinion.
I'll allow the question.
But I think, as I indicated earlier in my response to you, my colleague, Mr. Tesfaye, didn't indicate anything harboring on imprudent practices. So from that standpoint, they're no vehicle for us to move forward. Certainly, all parties would like to see costs move in a downward fashion. I think the company would agree with that. But I think that moves you into a position of, are the costs in question imprudent? In our mind, we haven't broached that topic. In our mind, we don't believe they're imprudent. If they were in fact imprudent, my testimony would have sponsored a certain element of cost. We are not doing that.
Mr. Tesfaye certainly has considerable testimony on Washington Gas's increases in leaks and leak management costs. And just to start off with, I'm looking at his table 4 on page 8 and his table 5 on page 11, correct?
Mr. Tesfaye's testimony speaks for itself. I don't have a copy sitting in front of me. But as I testified earlier, the number of leaks and the cost of leaks have gone up over the last.
I'm sorry, I missed the last one. The cost has gone up by, and then it just faded. Now you're freezing.
Mr. Valcarengi, I'm now getting a little yellow signal on my screen saying that you have connectivity issues. So would you turn off your camera and see if that helps, please?
Can you hear me now?
Yes. Yes.
I think what I had indicated was, I think it's certainly clear that the number of on WGL's system and the cost of remediating those leaks have gone up over the last few years. And what I'm saying is, we haven't identified anything of an imprudent nature that would warrant us to docket an investigation, if you will.
Thank you, Mr. Valcarengi. Your Honor, I don't have any more questions. However, I would like to move the admission of AOBA Exhibit 8.
Any objections?
No objection.
AOBA Exhibit 8 is admitted.
Thank you, Your Honor.
Does GSA have cross for the witness?
No, Your Honor, we do not.
Thank you. Montgomery County?
No, Your Honor.
OPC?
Yes, Your Honor. Thank you. Good afternoon, Mr. Valcarengi.
Good afternoon.
I do have a couple questions for you. If you could turn to your rebuttal testimony at page 3, let me know when you're there.
I'm sorry, you said page 3?
Yes. Are you there?
Yes. I said
Okay.
I have it. I'm sorry.
Oh, okay. Sorry. I was waiting for you. I didn't hear that. Apologize. Page 3, line 9. Here you address, starting at line 9 with the question and then continuing at lines 10 and going down with your answer. You address Mr. Coppola's recommendation to limit safety and reliability spending to the test year, correct?
Yes.
Okay. And you state here on end of line 14 and going on that Mr. Coppola cites order 84475 and 9267. Then you describe that order and state that the commission declined to authorize post-test year expenses and indicated they were reluctant to deviate from costs and revenues incurred in the test year, right? You see that going on? I'm on to page 4 now.
Yes, I see that.
But then you point out, you state that Mr. Coppola fails to consider more recent guidance, and then you talk about order 85374, and you describe how in that case the commission allowed post-test year safety and reliability spend. Do you see that?
I do.
And that order's from a 2013 BGE case, correct?
That's correct.
Okay. And then continuing on down page 4 at line 7, you begin to discuss Washington Gas's last fully litigated rate case, case number 9481, correct?
Yes.
And do you recall that in that case, the company's proposal was to recover 6 months of post-test year safety and reliability spend, and that OPC's position in that case was that that post-test year spending should be limited to 2 months post-test year. Do you recall that?
I recall there was an element of post year as well as what would I call it? Projected capital expenditures. The commission declined to include the forecasted capital expenditures. And I believe you're accurate. There was a 2 and a 6, 2 months or 6 months. I can't recall what number was specifically included within the commission's determination as I sit here.
Okay. Let me refer you to what's been marked. I'm going to use one of Montgomery County's exhibits. It was marked as Montgomery County Exhibit 5, and that is the commission's final order in 9481, the last fully litigated Washington Gas rate case that you mentioned in your testimony. The order number is 88944. Mr. Valcarenti, do you have access to Montgomery County Exhibit 5, or do you have just access to? Okay, do you have access? Okay, do you have access to order 88944 generally? That's the final order from case number 9481. Do you have access to that?
I do not.
Okay, Your Honor, I could take a stab at sharing this, or if Mr. Wilson wants to get the witness a copy, whatever your Honor's preference.
Let me start by giving you sharing rights, and Mr. Wilson can weigh in if he wants to do something differently.
Thank you.
Should be able to share now, Mr. Cleaver.
I think that would be the better path than asking me to do something on this computer.
Okay, let me now take a look and see if if the screen looks the right way. Can Your Honor?
On page 73 of the order.
That's right. Okay, I can't see the screen where it shows up, but I mean I have the order, so I can. Whoops, that's Mr. Volkerengi. I can continue. Can everybody see that now? I'm on page 73.
I can see it.
Okay. And again, for the record, this is order 88944, the commission's final order in case number 9481, the Washington Gas 2018 base rate case. It's been marked and identified in this case as Montgomery County Exhibit 5. Mr. Volkerengi, here at the bottom of page 73, the commission addresses this issue as it arose in that case. And as you can see here, I'm at the very last paragraph that begins on page 73. OPC's position to limit post-test year plan additions to May 2018, which the commission indicates is in parentheses 2 months beyond the test period, is on more solid ground. The commission's recent orders have emphasized that recovery of post-test year rate base additions and reliability spending is not guaranteed and should not be expected. Those cases also curtailed post-test year period recovery to 2 to 3 months after the test period. The commission then goes on. I'm not going to read the whole thing, but I'm going to go a little further. For example, during the recent PEPCO rate case, case number 9418, the commission allowed post-test period reliability investments 3 months after the end of the test year. The commission explained that allowance of post-test year reliability plan additions is an exception to the rule of allowing recovery only of reliability investments for the historical test period. The commission further stated that the exception was adopted several years ago to incentivize the company to make accelerated reliability infrastructure investments by allowing recovery of the expenses without waiting for another rate case. The commission reasoned that it had departed from traditional rate-making principles in the past in order to improve PEPCO's reliability performance, but did not intend for this exception to become deemed as guaranteed or automatic. Mr. Volkerengi, have you seen this order before?
Yes.
Okay, and if you continue down, I'm gonna skip ahead now. I'm at the very bottom of page 74 with the paragraph that begins there, last 2 lines of page 74. In the present case, however, the record reveals an increasing leak rate problem for WGL. It says what Mr. Chapman said about the issue, and then my memory has run out on my PDF here. Let me, may I reopen this for a second, Your Honor? Let me go ahead.
Yes.
All right, Your Honor, I'm ready to resume if you have, if I don't know if my image, my document's still on the screen.
We can see it.
Okay, thank you, Your Honor. So I'll start again, bottom of page 74. In the present case, however, the record reveals an increasing leak rate problem for WGL. The commission then quotes what Mr. Chapman of WGL said, it then quotes what Montgomery County said, and then states right after footnote 225 in the body of the text, in order to address that problem, therefore, the commission will authorize post-test year plan additions up to the hearing date, which is 6 months after the test period as proposed by staff. As stated in past rate case proceedings, the commission will continue to address this issue on a case-by-case basis with post-test year recovery viewed as an exception to the rule and not intended to be deemed as guaranteed or automatic. And you've seen that portion of the order too, Mr. Volkerengi?
I see that.
Okay, so so we're clear and for the record, when the commission here talks about an exception to the rule is that reliability spending and all capital spending is limited to the test year, correct?
Well, I think as you note in this order, the commission notes witness Chapman from WGL indicating that there was an ongoing leak problem. And that's the thing that I thought I indicated in my testimony, that the same types of problems experienced in 9481 are ongoing.
I understand. We'll get to that in a minute.
About advocating 4 months.
Mr. Valcarengi, we can get to that in a minute. We can get to the specific holding of this case in a minute and how it may relate to this current proceeding in your opinion in a second. But all I was asking you is just so we're on the same page for the record. When the commission here talks about an exception to the rule, setting aside the exception for a minute, the rule that the commission's talking about is that reliability and safety capital spending is limited to the test year, correct?
That's the general rule, because that way you end up with called a matched test year, where capital expenditures, revenues, and expenses are matched and developed into a revenue requirement.
Thank you, Mr. Valcarengi. The exception to that rule, as articulated in this commission case that you cite, this commission order that you cite in your testimony, is that if, as evaluated on a case-by-case basis, there's a reason to make an exception to that rule for a given utility, the commission will, in some instances, allow post-test year reliability and safety spending to be included in the calculation of the revenue requirement. Is that a fair statement of the exception to the rule?
I think that's states, yes.
Okay, thank you. Now, Mr. Valcarengi, I know you wanted to jump ahead to this. I'm sorry, 1 second. Hey, man, I can't talk right now. Sorry, everyone. Okay, I'll check it out in a minute. Come on. It's really good. Sorry about that, everybody. Being asked to look at an art project. I apologize. He's been good throughout this, but that was a breakdown. Sorry about that, everybody.
I think I'm not sure that you were enthusiastic enough about how good that art project was. I hope you revisit it later.
Thank you, Your Honor. Yes, I'll lay it on later to, try to erase any childhood trauma that I've just inflicted by my apparent lack of interest in the roller coaster art project at this point. So, let's see. Oh, right. Okay, so we've established the rule and the exception, and then Mr. Valcarengi, you had jumped ahead a bit earlier. So turning to the holding of this case here, 9481, where the order that we're looking at. In this case, the commission did determine, as you pointed out correctly, that in light of Washington Gas's ongoing leak problem, as the commission described it, for this case in 2018, Washington Gas was that it was appropriate for the commission to grant Washington Gas an exception to the rule, as we've defined those terms, exception and rule, correct?
Yes, that's what it says.
Yes, and the exception that the commission deemed appropriate in this case was what the company had advocated, which was 6 months post-test year, correct? And by this case, I mean 9481.
Yes, 9481 included 6 months of capital expenditures past the conclusion of the test year in that case.
Okay. Now, Mr. Valcarengi, if I could quickly turn you back to your rebuttal, and Your Honor, if it's okay with you, it's fine to continue screen sharing because I may go back to the order one more time, if it's okay with Your Honor.
Absolutely, Mr. Kleber.
Thank you. I have your rebuttal testimony up now, Mr. Valcarengi, and that's what I'm looking at. So when you say, and you explain here, I'm further down on page 4, you basically say what you and I just established, that in 9481, the commission noted the company's ongoing leak problem, and then down at line 12, you say that the commission authorized the inclusion of post-test year plant, which in that case was 6 months beyond the test year in that proceeding. If I could ask you, though, to go back up here to lines 8 to 11, you say while rejecting the inclusion of forecasted expenses, and you've already alluded to that, and that's not really an issue in this case. After the comma here on line 9, you say the commission indicated that WGL's proposal to include recovery of capital expenditures is consistent with commission precedent. Where in the order did the commission say that what the company had proposed in 9481 was consistent with commission precedent?
Well, I think the fact that the commission included those post-test year capital expenditures within the development of the revenue requirement says that it was consistent with their earlier rulings.
Well, I would agree with you that, and I think we all would agree, that the commission determined that based on the facts of that case, that Washington Gas was a good candidate for an exception to the rule, as we've defined those terms. But nowhere in the order does the commission say that what Washington Gas had proposed was, quote, consistent with commission precedent, correct?
Well, I would agree with that. The commission does not make that statement, but it is implied through the development of the revenue requirement that 6 months of capital expenditures included past the test year is consistent with what was done in earlier cases.
Judging the facts of that case on a case-by-case basis, correct?
Of course.
Right. Now, on that same point, similar point, I'm still on page 4 of your rebuttal, and I'm down on page 16. Excuse me, I'm still on page 4. I'm down on line 14. And you state here that at the end of the line, OPC witness Coppola's primary view is to reject the inclusion of any post-test year plant charges. This is simply contrary to established commission precedent. Mr. Valcarengi, isn't it accurate to say that what Mr. Coppola is proposing is actually the rule, as the commission has used that term and articulated it in the final order in case number 9481?
I would disagree with that. It doesn't take into consideration the facts and circumstances regarding plant that is continuing to, how would I describe it, affect WGL vis-a-vis their ongoing reliability problems with regard to leak management.
Well, Mr. Valcarengi, I think you're getting into the exception and whether or not there's a basis for the exception, and we'll get there in a minute. But a bit earlier, about 3, 4, 5 minutes ago, you and I established that the rule that the commission was talking about in Order 9481 was that safety and reliability spend is limited to the test year. That's the commission rule. Not talking about the exception, but that's the rule. You agreed with that.
I would grant you that.
And so what Mr. Coppola is proposing in this case is the rule, correct?
He's proposing a test year standard, which ignores the ongoing problem, which is mentioned in this order, i.e. the ongoing leak problem.
And you're, again, Mr. Valcarengi, you're jumping ahead to whether or not the facts of this case warrant an exception to the rule, and we can talk about that in a minute. But all I'm seeking to confirm with you is that the rule, as I articulated it and as you agreed, is that safety and reliability spend is limited to the test year, and that's what Mr. Coppola is recommending in this case. Correct?
Well, I think that's what a historic standard says, but every company over the past 6 or 7 years has included some element of post-test year capital expenditures within the development of the revenue requirement.
And in each of those cases, the commission has determined that, based on the facts of the case, that an exception to the rule is warranted, correct?
I don't know whether the commission articulates that in each and every order. But what I will tell you is I think what I said in my testimony is the facts and circumstances in this case are the same as those experienced in 9481. There's an ongoing leak problem. Here in this case, the company is attempting to recognize 4 months of 4 months of capital expenditure. It was 6 months.
Mr. Vaccarengi, let me ask it this way, because we're kind of going back and forth. I think both of our points are known at this stage. But let me ask it this way. Do you agree that the disagreement that you have with Mr. Coppola on this issue, as you discuss it here, is whether or not the facts of this case warrant an exception to the commission rule that safety and reliability spend is limited to the test year?
Can you say that for me again, Mr. Cleaver?
I thought I'd gotten it precise. Let me give it another stab. Do you agree that the disagreement that you have with Mr. Coppola on the issue that you address here, that we've been talking about, is whether the facts of this case warrant an exception to the commission rule that the recovery of safety and reliability spend in a rate case is limited to what occurs within the test year?
In this case, are part and parcel the same as those experienced by the company back in 9481. So it would be my recommendation to include post-test year capital expenditures as recommended, as proffered by the company.
I understand that's your recommendation. I didn't get an answer to my question. Let me try it again. I tried to shift the nature of the question because we were, I didn't want to belabor the point, but let me try to ask my question one more time. I understand what your conclusion is about the facts of this case, and we can talk about that in a moment. But I'm asking broadly and generally, don't you agree that the nature of your disagreement with Mr. Coppola on this issue, as you discuss it in your rebuttal testimony, is whether the facts of this case warrant an exception to the commission rule that the commission rule that safety and reliability spending recovery for that is limited to the test year?
I guess you could say that. There's a disagreement between myself and Mr. Coppola as to what level of capital expenditure should be recognized in development of.
Okay. Now, I think this is the part you've been waiting for. In your view, the continuing leak problem that the company's been experiencing, and that it's still experiencing, as has been discussed by Mr. Price and others, warrants an exception to the rule, as the commission uses those phrases, exception and rule in the 9481 order. It's your opinion that the evidence of a continuing leak problem warrants an exception to the rule for this case based on the facts, correct?
Well, that's what I say in my testimony. In fact, what I said in my testimony was the same conditions within this case are similar to those experienced in 9481. In that case, the commission, I believe, granted 6 months of post-test year capital expenditures. Here, it's, I think, a little bit less.
That's right. So let me ask you this question, Mr. Valcarengi. Now, this case 9481 that we've been talking about, the final order, that was more than 2 years ago, right?
I don't know the specific date of the commission's order, but I would grant you, I think it's 2018.
Yeah, would you accept subject to check that the commission issued its final order on December 11th, 2018?
Yes.
Okay. In your view, based on your experience at the staff, which has, you know, there's been a number of discussion, there's been a lot of discussion about that today. I know you're very well experienced. In your view, assuming this leak problem continues in the next case and the case after that and so on, is it your view that the company should continue to receive this exception to the rule limiting safety and reliability spend to the test year based on the ongoing leak problem in perpetuity?
It's difficult to say what's going to transfer the case. I mean, each case stands on its own, as you well know. I don't know. I don't have a crystal ball and can't sit here and tell you what the specific facts and circumstances regarding a test year in the future will hold.
That's understood, Mr. Valcarengi, but assuming that the leak rate level is similar to what it is now, speaking at a high level, do you think there's a point at which the commission should reconsider the grant of an exception to the rule, as we've been using those terms, based on the fact that the leak rate problem is not improving?
It's difficult to answer that question. There's no way of knowing what's going to happen in the future. Certainly, stride and reliability are significant spend, and there's nothing that I have seen that's showing that, at least in the short term, those items are going to go down. But leak management costs, sure, hopefully, in the near term, those items will rectify and they won't be as high as they are. But you know, that's speculative at best.
I agree with your hope that leak expenses go down due to stride or other activities at the company. I guess what I'm asking is, in your opinion, is there a point at which the reasons for granting this exception, namely, you know, using the commission's language to incentivize this particular type of spending, if it doesn't appear to be having an impact over years or over multiple rate cases, is there a point in time at which the commission should reconsider that grant of an exception to the rule limiting spending to the test year?
It's not a point that I've sat and thought about. We have got where post capital expenditures have become the rule rather than those that are germane specifically to a test year. Now, is there a specific point in time? It's difficult to put your finger on that. I mean, part of it is if you're not recognizing those elements, all you're doing is inviting another case at some point in the short term.
Well, on that last point, we've gotten a case 3 years in a row from this particular utility, correct?
Indeed.
Right. Okay. Okay. We can move on. Thank you, Mr. Valcarenci. Let's move on. If we could keep scrolling down. Now I'm at the top of page 5 of your rebuttal testimony. Are you
Page
there?
5. Yes.
Now, I know you made this correction with your counsel this morning, but this may be quicker than I maybe thought it would be. So I'm going to ask you about page 5, line 1, but before I do that, let me also ask you, let me ask you before I do that to turn to what's been marked as OPC Exhibit 17, which is a corrected staff data response.
Okay.
Okay. Are you? And I sent this around early this morning. I don't know if your counsel sent it to you, or you may just have it. Otherwise, it's staff's corrected response in this case to OPCDR 2-1. It was served on January 4th of 2021. Just I guess that was 1 week ago. It's about the calculation of the stride surcharge. Do you have that response?
I have this.
Okay. And we don't need to go through this response, but the initial response indicated that gas companies have always used a stride surcharge that used a terminal presentation in the development of stride rates. And then the response was corrected to say that the stride revenue requirement is calculated on an average basis. And just to be clear for the record, I think most everyone in this case knows this, but just so the record's clear, when a surcharge such as stride, for instance, is calculated on a terminal basis, what that means is, if you took a calendar year, you would look at the level of rate base at the end of the year, and you would calculate a revenue requirement on that basis, correct?
Yes.
And in contrast, when you calculate a surcharge such as stride on an average basis, what that means is that you take the plant balance at the end of every month over the course of a year, so 12 separate balances, and you add them together and divide it by 12 to determine on average throughout the course of this year what was the balance of plant to which the rate of return should be applied to calculate the revenue requirement, correct?
That's what an average would mean.
That's right. So an average is, at least in the context of stride, it's always going to be less than a terminal. An average approach is always going to result in a lower revenue requirement than would a terminal approach, which will result in a higher revenue requirement, correct?
For sure.
Yeah. Okay. I know we're in agreement on that. Just wanted to get it on the record. All right. If I could go back to the testimony here.
I did correct the data response, Counselor.
I understand, Mr. Valcarengi, and I pointed that out. I thought I did, but I will say it again for the record. I said, and then you corrected it to state that the stride revenue requirement is calculated on an average basis. No dispute for me there. Is the way I just described it accurate?
It is.
Understood. We're in agreement on that. And then, so I'm going back to page 5 of your testimony, and initially there was this comment about the stride surcharge being recovered on a terminal basis. I know you've since excised it from your testimony, which you did with your lawyer this morning or this afternoon. But when you filed the testimony, you understood that Washington Gas used the terminal basis. I know you've now corrected it, but that was your understanding at the time, and that was one of your rationales for disagreeing with Mr. Coppola, correct?
I don't understand the question as it relates to the testimony. I mean, I think my testimony speaks for itself.
Right. Look, it's not a trick question. Let me try to ask it again. When you initially filed your rebuttal testimony on December 8th, you stated, Mr. Coppola seeks to use an average presentation if post-test year plant charges are included. But plant costs recovered through the stride surcharge are done so on a terminal basis. A change in the valuation of plant transferred to base rates would provide less recovery than previously afforded through the surcharge and therefore is inadequate. That's what the testimony initially said, correct?
Yeah, and that passage was stricken.
I understand, Mr. Valcarengi, and I'm not trying to trick you, and I understand that. What I'm just trying to establish is that part of the testimony that's since been stricken that I just read, that was presented as a rationale, this mismatch between your previous thought that a terminal basis was used and Mr. Coppola was saying average basis, and you presented that as a reason for Judge Grace to reject the testimony.
Well, again, that passage is stricken, so therefore it has no weight.
Understood. And I'm just confirming that rationale is no longer part of your disagreement with Mr. Coppola. Is that fair to say?
Well, hence why I have removed it from my testimony.
Understood. Thank you. Your Honor, may I have a moment just to, oops, I think that's my trial notes. I shouldn't. Could I stop screen sharing, Your Honor?
Yes.
Bear with me, Your Honor. I apologize. I'm trying to get my screen back as it should look.
I just removed your presenter privileges, so your screen is no longer being shown.
Okay, now it's back. Thank you, Your Honor. Thank you. Your Honor, all right, now that I've settled that, may I have Your Honor's indulgence for just a couple seconds to review my notes? I'm near the end here.
No problem.
Thank you. Just one more brief line, Your Honor. Mr. Valcarengi, when you were talking to Miss Francis just a few moments ago, Miss Francis was asking you about the leak issues and the way the companies manage those, and you a couple times brought up something that you didn't see any imprudency comments along those lines. Do you recall that conversation with Miss Francis?
Okay. Let me hear.
Generally.
Yeah. And you, at one point, when you were talking to Miss Francis in the context of that discussion,
I don't hear
you
it. I
said,
gotta turn my sound up.
"Hey, Fran, you're not muted. We can hear what you're saying."
I just muted Miss Francis. Go ahead.
Oh, thanks. Sorry, Your Honor. I didn't mean to jump in, but I didn't want to, Mr. Valcarengi, you have, I jotted down here in my notes that you use, when Miss Francis was asking you about assessing prudency in light, vis-a-vis the company's management of its leak rate problems. You said we haven't broached that topic, and I didn't quite understand exactly what you were saying when you made that comment. Do you recall that comment? And if you do, what did you mean by that?
I do recall that comment. I think we didn't find anything, although there is an expansion in the number of leaks and the cost there too, we haven't found anything, at least looking at the data in the case, that would indicate that the company's actions were imprudent.
And when you say that, you're specifically talking about the company's actions in relation to the manner in which it's managed leaks?
What else? Sure.
Well, in other words, Mr. Valcarengi, I mean, a utility can be imprudent in any number of ways, but I'm just confirming that when you make the statement you just made, you're speaking, your comment is limited to the company's approach to managing the leaks on its system, correct?
The conversation that I had with Ms. specifically tailored to leak management and the company's proposal for an alternative leak management proposal. And what I indicated in that conversation, we didn't find anything on our end that would indicate the company's practices were imprudent.
So when you say you didn't broach it, you mean that do you mean that you did broach it and you didn't find any issue, or it's not something you really looked into?
Looking at the data, we didn't see anything that was imprudent.
And can you be more specific? What specific data are you talking about?
The data provided in the case. I can't point you to a specific document, but I mean, there's thousands upon thousands of pages of information within this case. What I would state is I haven't seen anything that the company's practices with respect to remediation of leaks is imprudent.
Right, and Mr. Valcarengi, I understand there's many documents in this case. I'm not asking you for a specific page number of an attachment to a DR response. I'm just asking you if you could, like, specifically what sorts of information you're talking about that you reviewed to make that determination.
I've reviewed the company's cost over a period of years. I reviewed the types of leaks over a period of years and how the company responds to leaks. I also consulted with technical staff's engineering personnel, and they didn't indicate anything was that the company was following a process that was imprudent. Standpoint, from my perspective, there was no reason to assert that the company's leak management processes and the cost were imprudent.
And Your Honor, I think Mr. Cleaver's questions here, and to a degree Ms. Francis's earlier questions, really are more suited to the engineering testimony. And I'm wondering why they didn't avail themselves of our engineering witness. I think we've let this go far enough as far as having an accounting witness discuss about the prudency of a leak management program.
Your Honor, may I respond? It was Mr. Valcarengi that addressed very specifically what Mr. Oliver was suggesting in terms of an incentive mechanism. So number one, I think that the cross that we did of Mr. Valcarengi was perfectly appropriate. However, the word prudence didn't come into my cross-examination. That was a new word by Mr. Valcarengi. We weren't asking about imprudence. What we were asking Mr. Valcarengi about was the growing number of leaks. Obviously, when you're talking about a hazardous leak, everybody knows the company is required to fix it immediately. They have to show up and remediate it. We're not dealing with that. My questions all went to the growing number of leaks, of which a staff witness has Tesfaye has considerable testimony. Mr. Valcarengi chose to put the word imprudent in. And as I hear what Mr. Cleaver is asking about, it's very hard to tell what Mr. Valcarengi is talking about when he talks about he reviewed the data and it wasn't imprudent. What wasn't imprudent? We were asking about the growing number of leaks.
Your Honor, if I could I be heard as
Mr.
well?
Cleaver, how many more questions do you have in this line of questioning?
Your Honor, I believe that I'm through, but may I just add? Yeah, I mean, OPC agrees with what Ms. Francis just said. Mr. Valcarengi, mentioned this in response to a question. I agree with Ms. Francis. I didn't hear it in any of her questions. He said it. The manner in which he described it, I didn't really understand. So it was something that caught my ear, and I was just following up on his own comments, a concept that he brought up for the first time. But I do think I can probably cut it off, Your Honor, at this point.
Thank you, Mr. Cleaver. I guess when you say cut off, do you mean you're done with your cross-examination, or do you have?
Yeah, I'm finished. That was yes. I'm finished now. Thank you, Your Honor. Thank you, Mr. Valcarengi.
Thank you, Mr. Wilson. Do you have redirect?
No, I don't, Your Honor.
Mr. Valcarengi, I don't have any further questions for you. Thank you for your appearance this afternoon.
Thank you, Your Honor.
Staff have another witness to call.
At this point, Your Honor, Mr. Albert will present Mr. McAuliffe.
Good afternoon, Your Honor. Thank you. I will be introduce Drew McAuliffe. We would call him as a witness. Mr. McAuliffe, what? Oh, he gets sworn in. Sorry.
Just a second, Mr. Albert. Mr. McAuliffe, will you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Can you spell your last name for the court reporter, please?
Sure. McAuliffe.
Go ahead, Mr. Albert, your witness.
Thank you, Your Honor. Good afternoon, Mr. McAuliffe. Did you file direct testimony on this case on November 20th, 2020?
I did.
Oh, I'm sorry. I'm supposed to back up a second. What is your job responsibilities and your job title at the commission?
I'm currently the director of the electricity division here at the commission.
And you are in that capacity responsible for reviewing rate cases?
Yes.
Okay, and again, let me go backtrack there. You did file direct testimony on this case in November 20th, 2020?
I did.
Your Honor, we would ask, if I got the sequence right, that Mr. McAuliffe's direct testimony be marked as staff exhibit number 21.
Staff exhibit 21 is marked.
Thank you. And Mr. McAuliffe, did you file surrebuttal testimony on December 21st, 2020?
I did.
Do you have, Your Honor, we would ask that Mr. McAuliffe's surrebuttal testimony be marked as staff exhibit 22?
Staff exhibit 22 is marked.
Mr. McAuliffe, do you have any revisions or changes to either your direct testimony or surrebuttal? Your Honor, we would ask to introduce into the record Mr. McAuliffe's direct testimony as staff exhibit 21 and Mr. McAuliffe's surrebuttal testimony as staff exhibit 22.
Any objections?
None from the
Hearing
company,
none.
Your Honor.
No objection.
Thank you. Thank you. Hearing none, staff exhibits 21 and 22 are admitted into the administrative record.
And with that, Your Honor, we would present Mr. McAuliffe for cross-examination.
Mr. Buckley, is there cross-examination on the behalf of Washington Gas?
Yes, there is. Thank you, Your Honor. Very limited in nature. Good afternoon, Mr. McAuliffe.
Afternoon.
I don't know if we've had the pleasure of meeting, or if we did, it was probably one of the admin meetings or something. So hello.
Hi. Meet you.
I would like to compliment you, however. It's a very rare talent to be able to address cost of capital testimony in something less than 75 to 100 pages, and you did it well. Very rare talent looking at the other witnesses in the case. So I only have a few matters for you, sir. First of all, again, your recommendation on return on equity in this case is 9.6%, correct?
Correct.
And you did recently also testify in the Baltimore Gas and Electric case, and also made a recommendation of a 9.6% return on equity for the gas division of BG&E?
Correct.
In that same case, Mr. McAuliffe, you also testified that, or recommended that the electric division get a lower return on equity of 9.4%. Do you recall that, sir?
Yes.
So in the commission decision that was rendered, I think the date was December 16th, but don't hold me to that. I don't have it written down. And I do believe that was case 9645. Is that right?
That's correct.
So in the commission decision, they did agree to a higher return on equity for the gas division than the electric, correct?
That's correct.
So their decision was a 9.65 for gas and 9.5 for electric?
Yes.
So I gotta try. So now that you know that your recommendation was very close, but not adopted, do you want to raise your recommendation here for Washington Gas to make it 9.65?
I do not.
Had to try. So, Mr. McAuliffe, in the BG&E order, and I presume since you were a witness in that case, you've read it and you're familiar with the rationale for the commission's decisions on equity as well as capital structure?
Yeah.
So do you recall, sir, and this is at page 154 of the decision, the commission noted that they were making a nominal downward adjustment to BG&E's then existing levels of ROE. They cited a couple of factors, and let's see if we can get an agreement on the factors that they made, and then which of those elements are applicable to Washington Gas. So they said first that there were changing market conditions as well as declining interest rates. Do you recall that?
Can you repeat the page, please? I actually have that up.
Sure. And I'll bring it up on my screen too, so I can try and make sure I get this right. So it's in paragraph 343, starting at the bottom of 153. I'm sorry, it's in paragraph 344 on page 154. And it's about midway through. They note that although the rates reflect a nominal downward adjustment, and then they go on to explain some of the rationales for why they were setting the rate at the level that they did. Do you see that?
Mm-hmm.
So they say that there are changing market conditions as well as declining interest rates.
Excuse me. Your Honor, could you instruct the witness to say yes or no? It doesn't work. Please.
Mr. McAuliffe, just try to answer affirmatively or negatively formally, please. Thank you.
Yes.
That's okay. Thank you. And if you have any questions, Mr. McAuliffe, or you need me to slow down or something, just chime in and we'll work through it. So let me go back again. So this commission cited several factors to support their rationale, one of which was changing market conditions as well as declining interest rates. Do you recall that, sir?
I do.
And that would generally be applicable, in your expert opinion, to Washington Gas as it was with BG&E?
Yes.
Similarly, the commission also noted a downward trend in the return on equities from commissions around the country. And do you recall that?
Yes.
And that would also be applicable, again, in your opinion, to Washington Gas, right?
Yes.
Let's take a look at a couple of other factors, though. First of all, in that case itself, the commission did note that the appropriate return on equity finding for the electric division is lower than it would be for gas, as you noted before, correct?
Yes.
And Washington Gas is a natural gas distribution utility solely, does not have any combined combination utility service. There's no electric service component, correct?
Yes.
So that part of the BG&E decision is not applicable to Washington Gas, correct?
Generally, yes.
So later on in that same paragraph, the commission made a final conclusion regarding that, where they stated that the return on equity that they determined for BG&E was going to recognize the reduced regulatory lag and the risk that stemmed from the multi-year rate proposal, correct?
Yes, the commission does note the reduction in regulatory lag. However, they don't apply any specific adjustment for that. It's just listed as one of the many reasons for the awarded ROE.
And they didn't
Your
support.
Honor, if I may, I'm sorry, this is Kenneth Albert on behalf of staff. Yeah, I took a couple of minutes to pull up the decision. Can you give me, Mr. Buckley, the paragraph site you're working from?
Of course, Mr. Albert. It is at the it's on page 154, and it's paragraph 344. It's from the middle of that paragraph down to the bottom.
Thank you.
Well, take your time if you want to get your recollection refreshed and catch up to us. You good, Mr. Albert?
Yeah, thank you.
Okay. So, Mr. McAuliffe, all of those elements that I identified, the commission didn't identify a specific basis point adjustment, did they?
No, they did not. That's correct.
And isn't it also true that it was a rather significant issue in the testimonies of various witnesses as to whether there should be an adjustment related for an acceptance of a multi-year rate proposal?
Can you please repeat the question?
Sure. So you were a witness in the BG&E case.
Yes.
Is it match your recollection that the issue of whether there should be an adjustment or a recognition of reduced risk due to an acceptance of a multi-year rate proposal? Does that match your recollection?
The company did not bring up that argument. Specifically, I brought up the argument that a reduction in regulatory lag should lead to a lower awarded ROE. Yes.
And that is not applicable in this case since Washington Gas does not have a multi-year rate proposal on the table, correct?
No, obviously no. Washington Gas did not file a multi-year rate plan.
So, Mr. McAuliffe, if all other factors were equal, the fact that Washington Gas doesn't have a multi-year rate plan means that the finding of a return on equity should be higher than the BG&E determination, correct?
Not necessarily.
So one other factor I want to just get to about the determination regarding the electric differential between gas and electricity. And I know you've been with the commission for 4 years. Do you recognize this as being the first determination from the Maryland Commission in recent memory? I'll call it 2 decades. Old guys get to use 2 decades as recent memory. The first determination from the commission that there is a lower level of risk for electric divisions compared to gas divisions? If you know.
I'm not aware that it's the first. I think a lot of it has to do with the changing dynamics of utilities. Obviously, as you know, there's not really vertically integrated natural gas utilities.
And are you aware? Understood. I'm sorry. Did you finish your answer?
Yeah. Yes.
Okay. Are you aware that the commission has, for some period of time, certainly over a decade, has had a differentiated return for the electric and gas divisions for BG&E, with the gas division having been lower than the electric until this recent decision, if you're familiar.
They've been relatively higher than the electric. Has been higher than the gas ROE. It changes from time to time. But I wouldn't say that the natural gas is necessarily more risky than a distribution.
And that reflects the testimony in the BG&E case, right?
Hold up 1 second, please.
Okay, sorry.
Mr. McCall, I'm really not picking you up real well. If you could just lean in a little closer, we'll try that. You're cutting out just once in a while, not much, but I want to make sure I get every word you say. Thank you.
Mr. McCall, if you want to feel free, if the judge agrees, you can go ahead and kill the camera. That seemed to help Mr. Valcarengi's feed.
Yeah, I think the computer was just a little distance away. So as I was saying, I don't think that distribution utilities, particularly natural gas to electric, have much difference in risk at all. The big difference is between vertically integrated electric utilities and natural gas distribution utilities.
Understood. Can I get you to turn, please, to page 155 of the commission order? This is in paragraph 348. Just get an acknowledgement from you regarding the commission standard there at the top there, where they talk about the longstanding precedent on utilities capital structure is that they utilize test year ending capital structure. Is that correct?
They have used that prior, that they do not always use the actual test year ending capital structure.
Well, they did mention it as a longstanding precedent. I don't think that they use the word always, but you do recognize that it's a longstanding precedent, as the commission itself said, right?
I say they use this often than not. However, they have imputed different specifically for.
Sure. Do you have Mr. Bonowitz's direct testimony available to you, sir?
Yeah, I do.
And I'm just going to get a confirmation on a fact from you. I don't believe that we need to share this, Your Honor. It'll be a quick question or two.
Have it.
Okay. Can I get you to turn, please, to his exhibit DIB-3? This is, again, appended to his direct testimony.
Yes, have that.
Just make sure I'm reading the schedule correctly and get an acknowledgement from you. Across the top of that, the different rows there with the different dates, those would be the various quarters of the cap with reflected capital structure, correct?
Correct.
And so specifically looking down at the end of the test year period of March 31st, 2020, it would show the common equity ratio on that date as being 53.49. Is that correct?
Yes.
So that would reflect on Washington Gas's actual test year ending capital structure, that figure there, correct?
Yes, that would be their capital ending of their test. But that is not what witness Bono was proposed in this case.
I understand. Thank you, Your Honor. That's all the cross-examination for Mr. McAuliffe. And Mr. McAuliffe, thank you very much.
No question. No question.
Thank you. GSA?
No questions from OPC, Your Honor.
No questions from GSA. No questions from Montgomery County.
Mr. McAuliffe, I have no questions for you. Mr. Albert, do you have redirect?
Yes, Your Honor, real short, if I may. Mr. McAuliffe, you were asked by Mr. Buckley a bit about the BGE multi-year rate case, that there was a higher higher return on equity, ROE, authorized for the gas versus the electric divisions of BGE. You recall that? And you mentioned something about, Mr. Buckley asked you something about why that may have been the case, and you said something about a vertically integrated utility. What were you referring to there?
I'm only going to narrowly object, Your Honor. I did not ask that question. Mr. McAuliffe did offer that as an answer. So if Mr. Albert wants to follow that up, but I did not ask the rationale for the differences.
That's correct. But go ahead, Mr. Albert.
Yeah, so I just want to ask Ms. McAuliffe, could you, didn't mean to mischaracterize it. I was working off what you said, Mr. McAuliffe. You made reference to the fact that on the electric side, there may be vertically integrated utilities. What was the point you were trying to make there?
Past higher gas are because of the inclusion of vertically integrated electric utilities. So electric utilities that own electric generation as well as the distribution system. So for example, Exelon, which we're very familiar with in Maryland, they own nuclear power plants, coal power plants, things of that nature. So vertically integrated utility, both electricity and distributes it, which are considered riskier because the generation as well. The generation is considered riskier than a distribution system on its own.
Okay, and then you were asked by Mr. Buckley about Mr. Bonowitz his scheduled DIB-3. Now you have, again, proposed an average capital structure. Why did you not just use the terminal capital structure?
Well, and there were some large swings in WGL's capital structure over the course of the test year. And the fact that there was an equity infusion within the last weeks of the test year from the parent was slightly concerning. So that's why I felt the average was more appropriate because of the variations over the year. As Mr. Bonowitz seemed to allude to on Thursday, these transactions happen all the time. So to set the capital structure right now that is appropriate for the next year, I don't know that it's always changing.
That's all I have, Your Honor.
Thank you, Mr. McCullough, for your appearance today. You are released.
Thank you.
Does that conclude the evidence for staff?
That's correct, Your Honor.
Okay. There are a couple of outstanding matters. See if I can remember what they are. Mr. Dodge circulated a new WGL Exhibit 30, and I believe it had included in it the responses mentioned, but I think he may have added a response to 3-12. So I was going to see if Mr. Cleaver had any objection to the inclusion of response to 3-12.
Yeah, thank you, Your Honor. I did see that. I do think that that was mentioned to Mr. Coppola, but then when we went over them at the end, I think that's what Your Honor's referring to. I don't think we talked about that one. Yeah.
Yes, I apologize. That was my error.
Yeah, I didn't have it either. I missed it on my notes also. Could I have a moment, Your Honor?
Sure.
Yeah. OPC can withdraw the objection to 312.
Okay. So WGL Exhibit 30, the newest circulated version, which includes 3-1 through 3-5, 3-8, 3-9, 3-12, and 319 is admitted. Now I'll turn to Ms. Francis regarding the confidential version. So let's not talk about it in detail of Bench Exhibit 1. What is your stance on that at this point?
I'm going to try to talk about it without mentioning any specific numbers. And I think that, okay. First of all, I have an overall objection to it. First of all, it's not sponsored by any witness. It's the last day of hearings. Washington Gas knew back in December that Mr. O'Brien was retiring. They had plenty of time to produce this earlier. This raises more questions than it answers. For example, there seems to be an implicit assumption that any time something is not specifically earmarked for an affiliated entity like WGES or Sempra, that Washington Gas, the utility, is the catch-all. In other words, everything, all of his time where they don't have a specific number assigned to a another entity other than the utility Washington Gas, they just lump all into Washington Gas, the utility. So we think that is totally inappropriate to start with. There doesn't seem to be the allocations that would be required of somebody in Mr. Jenkins' responsibility, as opposed to Mr. O'Brien, who had much less responsibility than Mr. Jenkins. He was executive vice president of Alta Gas, as well as president of U.S. Utilities Alta Gas, as well as president of Washington Gas, the utility. So on its face, it just doesn't even make sense to me. If you take a look at the very small amount of percentage that is allocated to entities other than the utility, and I can say I see that online. It says percentage of time in ALL meetings representing Washington Gas, and you look over and you see, two numbers. The way that they've allocated his time does not appear to bear anywhere near the responsibility that Washington Gas would require. For example, with Semco, that's 25% of the customers. The rate base of Washington Gas is considerably less than what they are allocating to Washington Gas. The revenues are significantly less than what they're allocating to Washington Gas. It just appears to be incomplete, that there's no documentation supporting it. The numbers on their face don't appear to be consistent with other numbers in the record, such as the amount of rate base that Washington Gas consists of, the amount of revenues that Washington Gas consists of. The amount of assets that Washington Gas has, the percentage of employees that Washington Gas has. Also, this is based on a quarter. We don't know if this is an aberration. It's not annualized. Do we need to normalize it? It's very difficult to tell from this late filed exhibit whether it's accurate. To our first reading, it doesn't even be considered plausible. So we object to it coming into the record at this late date. If we had had more time to submit discovery on it, if we had more time to prepare cross-examination, if we had some background of it, perhaps then, but not at this late date. And Washington Gas had knowledge in the middle of December that they were going to be replacing their witness. They should have filed this considerably sooner.
Does anyone else want to be heard on this exhibit?
The staff would join that objection, Your Honor. And the staff would also note the discrepancy between what Mr. Jenkins' own estimate was and what we were presented with by the company.
Anyone else? Okay, what I'm going to do. I'm sorry, I pressed mute halfway through my sentence. What I'm going to do is I'm going to admit bench data request 1C confidential and bench data request 2 on my own motion. But you all can make your arguments in brief based on how much weight should be given to that document. I believe that concludes my list of housekeeping matters. Does anyone else have housekeeping matters? I see Mr. Albert raised his hand first, Mr. Dodge, so just hang on.
Your Honor, given that we do have just one round of briefs in this case, under Comar, it's a 60-page cap on a brief. Staff would request a 75-page cap, given that it is just one round of briefs.
I don't have a problem with that.
Washington Gas is fine with 75 pages, Your Honor.
Does anyone object to that? Okay, 75 pages for brief limit. Mr. Dodge.
Thank you, Your Honor. I'd just like to confirm one thing and then make a request of the court reporter that I suspect others will share. The first, I want to make sure for record purposes that we are supposed to file written versions of material that has been admitted to the record but not previously docketed in the case.
Yes, sir. Thank you.
Thank you. And if Doug is on the line, we would request a rush transcript.
Okay.
Thank you. That's all I have.
Mr. Cleaver.
Thank you, Your Honor. Your Honor, as I was reviewing the schedule for the case, it occurred to me, I know we scheduled the public comment hearing late in the process. The public comment hearing, and I didn't, this escaped me at the time. I think I forgot about I lost track of the fact that there was no reply brief. Public comment hearing is actually the day after briefs are due.
It is.
I'm just wondering if, I mean, I can say, Your Honor, and I know Your Honor knows this, it's very rare for a party to talk about public comments in a brief. And, you know, the virtual public comment hearings I've been to, I don't know how representative they are of what, you know, of how this one's going to be, but there hasn't been a lot of attendance. So I think this is largely academic, but I do have a concern in the event that there is some comment made at the hearing that we would like to include in the brief. Would Your Honor entertain like a very brief, no pun intended, a very brief, some kind of errata or something to include a brief discussion of any public comment that anyone hears that they wish to include in their brief, even though it will be after the submission of the briefs. I don't anticipate OPC is going to need to do anything like that, but it is a concern because I do think there's been an occasion or two in the past where we wanted to include something that we've heard at a public comment hearing in the brief.
So I've given some thought to this, and what I'm going to do is I'm going to leave the record open. I'm not sure that, who knows if there's going to be something that's pertinent or something that someone wants to weigh in on. So I'm going to leave that open to you all. If there's something at the public hearing that you feel like you want to address, ask me at the end of the hearing. Help me remember to ask you. And we'll address it at that time. I'm not sure that an errata to a brief is the route that I want to go. And it'll kind of depend on what happens at the public hearing. It may be just allowing additional letter from each party or something like that. So I want to keep it as simple as possible. And yes, the opportunity will be there if necessary. Thank you for bringing it up, but we'll address it at that time.
Your Honor, I would say for the record that the company agrees with Mr. Cleaver. We are not opposed in any way to the concept that he has raised and that you have refined.
Okay, just everyone help me remember at that time because it's not my usual public hearing script. I will ask at the public hearing if there are other folks on the hearing for the company to give a short presentation as to what is encompassed in the filing, and for the other parties attending to give a brief description of their role in the proceeding. Mr. Albert has a question.
Your Honor, with respect to filing of the cross exhibits, the hearing exhibits, is that one copy with the secretary?
Just one copy addressed to me. I have to put it together and make sure that the record is complete.
Okay, so it's a paper copy addressed to you. Thank you.
Correct. Folks, participating in a rate case requires a lot of patience, and you guys have done wonderfully. Participating in a rate case on a virtual hearing requires an exceptional amount of patience, and I really want to thank everyone for working congenially together and for making this process as easy as can be. I'm thankful and grateful to all of you. So, oh, Mr. Dodge raised his hand.
I'm sorry, Your Honor, it's probably too late, but the company would not oppose as bench exhibit 3, the roller coaster art project.
I am kind of curious as to how that is. I'm sure that it's great. Yeah, we'll do that on the company's motion. But yeah, thank you everyone. This has been relatively easy as far as these hearings go, and it's because you all have made it easy. So I'm really grateful to you. And with that, I think we're done.
Thank you, Your Honor.
Thank you, Your Honor.
Good job, Your Honor.
Thank
you all for the record.
everyone.
Thanks, Your Honor. Thanks, everyone.
We're off the record.
I guess we're leaving.
Don't worry, I'm going to end it and kick you out, Mr. Wilson.